Well, hey folks, happy Friday to everybody. I hope everyone had a wonderful week. Hope you guys can hear me. I was having mic issues a little bit earlier, thus being a little bit late. So it's been a week for me. It's been 2 weeks, and here we are. A lot going on. Happy Valentine's Day to everybody. Happy post Super Bowl. Happy February 16th. My gosh, February 16th. Where did time? Well, time just doesn't exist anymore. So, how was your week? Where are you tuning in from? What are you guys doing? Hopefully, you guys had a wonderful week. Let's see. Hey, glad you're here. Hey, thanks, Fat Yoga. Thanks for being a member. Uh, let's see. Alicia, happy you're back. I'm glad to be back. Thank you. Thank you for being a member as well. Everyone's waving and saying hi. What are you guys doing? Are you having cocktails? We've got some fun stories tonight. We've got 3 stories that I had planned to cover, and then one that, well, I have to kind of talk about at least a little bit. So the 3 stories planned to cover, we've got Hannah Gutierrez-Reed. We will wait until a perhaps spicy Canadian joins to discuss that one. Then I've got a lawsuit that I never thought I would see. A golf company, TaylorMade. TaylorMade is now suing Costco. You heard that right. TaylorMade, the golf company, is suing Costco. So, of course, that intersected with 2 things that I love very much, both Costco and TaylorMade. Um, and that's been rather curious to me. Hang on one second. One sec. And yeah. So, bunch of stuff to cover, bunch of stuff to talk about. And then I've got a fun one, which is McDonald's Corporation. Who's ever been through McDonald's, whether it's with kids or otherwise, and asked for ice cream because the kids demand ice cream? Kids demand ice cream all the time. But the McDonald's ice cream machine is broken because it's always broken. Well, there's a lot of back and forth on that issue, like a lot. And there's a lawsuit that to be candid with you, this lawsuit was one that I saw on a Instagram reel that was going, "This is wild." And I pulled up the pleadings and I pulled up the suit and I was like, "Oh, this is too good. This is too good not to share." So we're going to go through that. And then I have to make some brief comments, probably at the outset, about one of the crazier things I've ever seen in court. And that happened in Georgia. Before we go too much further, I am being asked, I have been asked by Mischief One, Mischief Manager, and Mini Mischief One have asked that, Leo, our little Leo, has his own Instagram page. So if puppy content and this type of puppy content is what you're looking for, this is where you find it. Because Mini Mischief came home and she was like, "I want to see all the Leo posts. Are there comments? Are people asking questions? Are people seeing questions? I want to see what's happening." So really cute, really cute. He is his own pup, and I hope that page becomes more popular than any page I could ever manage myself, because that dog is chaos. He is chaos incarnate. Yeah, he is. And he actually resulted in a little copyright claim on Ian's stream because I shared a video, and of course the video had music. Of course it did. So Ian did the whole stream on the Gutierrez-Reed lawsuit, which I'm going to cover a little bit tonight. And I sent him the video of Leo, and of course it had music. So Leo's going, or Ian goes to me, why is there a copyright claim? Because that one little video. Who is Mischief? Mischief is Mischief Manager. Mischief Manager is my fiance. And she has been in the background, kind of, managing the mischief that I sew about for quite some time. So Leo is our little pupper. Doberman is going to be a big boy and is growing way too fast all the time. Way too fast. All right, good. Oh, no, thank you. So Ian had to send me the video for the Gutierrez-Reed hearing because that hearing was too big and had been taken down. So now I got to figure out how to download the damn thing. You know what? We're going to let that go for a different day. Let's see. Hmm. Let's do that. Sorry, folks. It's the glory of YouTube. And the glory of YouTube is that while you are always trying to plan things, there are little bits of chaos that come intermingled. And, people always ask me, why do you do YouTube and how do you do YouTube? Because I do live streaming. I can't do pre recorded videos. Uh, I don't have the time. I don't have the bandwidth. I don't have the capability. I can't actually spend the time to take all of that and make a video. I know that people can. I can't. Today I was in court and it drove me nuts. I was in front of a judge today who loves to, I don't want to say too much about the judge, but the judge loves to wax poetically on the intricacies of law and discuss things left, right, and center that might not be relevant to your case. And if you're in front of this particular judge, you are guaranteed to get at least one inner monologue per hearing. It is wild. So that led to me being on the 11:30 docket and this judge at 12:30 still working on his 10 a.m. docket. So opposing counsel and I wisely went outside and hashed through our arguments and entered an order that was a consent order that, thank God, is going to prevent us having to wait there until 3 o'clock when the judge was eventually going to be able to hear us. Is part of the job. It's part of the thing. So that was a lot of my week, and it's been fun. I will say the addition of a puppy to the household has led to even less sleep than I was otherwise used to. It has led to lovely moments of chaos that are fun and lovely moments of chaos that are not. One development is that Leo has now learned how to hit. We have those little buttons, the ones that say, bring me food. Well, we have one that says outside potty. And we are so happy because he finally apparently hit the outside let's go potty when he had to go pee. Yeah, that's going to help a lot. It's going to be so awesome. And I see people in the chat asking how the cookie sale went. So for those of you who were not aware, last week or 2 weeks ago when I was last live, my paralegal had approached me prior to that Friday Night Frenzy and had said that her daughter was selling Girl Scout cookies and asked if I'd be so kind as to post a link. And I said, sure, absolutely. This paralegal is a rock star, as are all the people that work with me at Whitbeck Bennett. So paralegal's a rock star. And I was saying, I will absolutely support this. And the chat came through. There were 918 boxes sold. And one of the coolest things about that is that apparently when you hit over 500 boxes sold, it basically means that that young lady, that young girl's Girl Scout membership dues for the next year are paid. So it's really cool. Oh, she also got a pair of Crocs. So it's really cool what you guys did. It was amazing. I got a lovely message from my paralegal, and she said she sent it through happy tears because she never imagined that could happen. But I knew it. I just knew it'd be the case. I knew that everyone would come through. I knew that the second I posted that link, it was one of those things where I was about to tell the paralegal, you don't know what you've just done. The chat came through and did some amazing stuff. And I know that there's also some people that have some needs in the community. One of those is Dr. Moo. Dr. Moo's been a long time follower, and I know she has a GoFundMe, and I've told mods that they can go ahead and post that link if they see the opportunity to post it and people are asking about it. So you can go and check that out and contribute if you're able to. Oh, look at this, spicy Canadian.
How you doing?
I'm doing well. I was talking about your client for a minute who he learned how to press a button. The button says outside potty. So
that's a weird button.
Well, it's like a little tabby thing. He walks over to the front door and he hit the outside potty to let us know. Well, to let Mischief know. I got to go outside. I got to pee.
I should get the puppy another button that says I want a treat. And then that can just be a constant sound in your house.
Treat. No. Terrible. You've seen the video that, although the contentions are the video is edited, that Leo has found access to cables behind computers, and that's been a fun exploration. So that's been interesting. How's your week been?
Oh, it's been good. I mean, yeah, no real complaints. I haven't had any acorns fall near me, so that's been that's good. Because
are acorns falling a thing?
Do you not know about this one?
Go on, and I might. Why?
There's a police officer who
oh no, I saw
an acorn fell nearby.
Horrible.
Yeah, it is.
Yeah, I've seen that.
Oh my God, I'm in danger. It's like, no, you're not.
Well, finish the story. The acorn falls, and the cop thinks he's being shot. And the cop,
and it's not really clear why he thinks that, other than just the cop is not a great cop. But so he goes and does like a John Wick roll and unloads on the police car. And this is where he makes his big mistake. So he unloads on the police car where the handcuffed arrestee is there. That person, through some miracle, is not shot, but he unloads his entire mag into the cop car. So that's really where he gets into trouble, because if he hadn't damaged police property, I'm sure he'd be fine. But so I'm just marking myself safe from acorns on Facebook. So
well, so oh gosh, that case is going to be, I don't know how you get around that. I saw that video multiple times. At first I watched it muted. Right? So the video was muted because I was watching it while I was actually, let me do this. I'm seeing that people are seeing ads. Let me freaking go to YouTube and say, do not put ads in any of this crap. I don't know if I can, but I will try. Because I don't want people who are watching this live to deal with that crap. I watched the video first, and I watched it live, or I watched it muted because I was. Let me see.
Oh, and there's people who think I'm being unfair to the police officer. He thought he was being shot by a silenced pistol from the patrol car. There was no pistol found. And yeah. The police investigation found this to be inappropriate, so there isn't anything fair. Like, this ain't unfair here.
This is a warning to you. Mom is in the chat.
A warning or an opportunity for mischief?
I don't know. Mischief manager doesn't only manage my mischief. She manages the mischief of the impossible mischief to be managed, which is being Runkle. So, yeah. But let me see. I wanted to pull a little picture up real quick of your client. And I'm trying to, let me see if I can't do this. Yep. So just popping in. Mom, what are you doing? Like,
yeah, that's going to be way less cute when that dog is bigger.
I know.
Because,
but it's the eyes. It's the eyes.
Yeah.
Like, can you give me attention?
And for the people who
So-
think I'm being unfair, we're going to go through the whole thing, including the 44-page report on Monday.
Ooh, that's going to be interesting to see.
Because, yeah, there's a 44-page report. So, yeah.
Well, we'll get into it. I'm sure that Monday is going to be interesting. We're supposed to get 3 inches of snow this evening. That doesn't bother me. I have the truck.
But 3 inches of snow.
You know, you laugh, but here's the thing. Here's the chaos. Here's the chaos that snow brings. Snow brings the chaos that snow usually brings, which is a difficulty in traveling. That chaos is exacerbated by people who don't know how to drive in snow. The DC area is notorious for people who do not know how to drive in rain or snow. They don't understand it. They don't comprehend it, but they still go to their job because they feel like they have to.
Because their boss doesn't understand that, maybe they could give a snow day for people who don't understand that, yeah.
It is wild. So anytime there's any semblance of snow in the horizon or a smell of snow in the horizon, the DC area freaks out. I mean, we had a kids started school 2 hours late today because there was a warning of possible snow during the beginning of school, but it wasn't cold enough for any of it to stick. So it was just that snow would be falling. I don't make the rules. I just try to abide by them. Anyways, we've got a lot of stuff to cover, and let's see. We get caught up on some of this stuff so that I can roll the intro and get going. Amber Brock, thank you for gifted memberships. Poppit, thank you for gifted memberships. The gifted memberships are incredible. Y'all are amazing. Baby Steps, thank you for gifted memberships. SFD, thanks for becoming a member. Fat Yoga, thanks for chatting and saying hi. Glad you're here. Glad you're here. Beep, bop, boop, arg. Look, another milestone, Whiskey 77. Look at that. Member for 14 months. My gosh. Nikki Lewis, member for 5 months. My wow. Catherine Cordell, thanks for becoming a member. Tamara Cartwright Lowell, greetings from the future. I guess you're ahead of me in time. Jessica MCFC, been a while. Hi, hope you're well. Missed everyone. Lisanne Morley says, hi, Rob. So glad you're back. I'm glad I'm back too. Megan Brogdon says, hi from Australia. Lunchtime here. Pats for Leo. Leo loves the Pats. Traveling Science Man, Rob the Lawyer. Is he busy? Rob the Lawyer. Yes, he is. Yes, he is. He is remarkably busy. I don't think I left the office before 7 o'clock this evening, any day this week. So, Charlotte DeRoche, good to see you, Rob. Thank you. Good to see you as well. Aqua 46784, folding laundry. Thanks for the super chat. And with gin and lemonade close at hand, you're going to need it. And about to be snowed on again, New Jersey, ready for some restorative FNF. We'll get there. We'll have some fun. Finally freed. My family court hearing was a soul crushing today. 5 years and counting. I'm especially thankful for your kind-hearted approach to the tough topics. Finally freed. Family court is remarkably challenging for everyone involved. And I'm sorry that you have gone through that and continue to go through that. Try to keep your head up. There are lawyers, and I tell you that the judges, I know people have disagreements with them, but a lot of them are good. Some of them are not. But never
Do you have
stop
any
fighting
names for
your
which
family.
ones are not?
No, I do not. I practice in front of them.
You don't
We have
want to
disagreements.
name any specific judges as not good?
Nope, not going to do that. Not gonna do that. KT, who's been a member for a month. KT, you've been a member longer than a month. I know you have. Happy you're back this week. I'm happy I am too. Bop it. Thank you. Shop update. Almost done with the mobile stand for the 8-inch jointer, the Rycon. I have that jointer. Send me a message,
Of course
DM
you do.
or email. No, that specific one.
I know. I'm just saying. Of course you do.
I know it's finicky and it's a pain in the butt. I got it because it was so much cheaper than the larger full base ones. But I will tell you, you need to secure that mobile stand. Laura Christine, thanks for gifting memberships. Much appreciated. Shiraz, I got my Girl Scout cookie. How we do? 918 boxes that night.
Dang,
918 boxes.
They're like, we are sold out of Girl Guide cookies.
You made
the entire planet.
You guys made an 8-year-old girl and her mom exceedingly happy. Like I cannot describe. So really, really, really awesome. Rocket Top Girl just answered that question. How the Girl Scout cookies sale go? Phenomenal indeed. Debbie Blair, enjoy every minute here. Thanks, Rob. Mods in chat. Thank you to the mods. I'm wearing some sample merch, and I have wanted to finalize it, but my rule is the mods have to get it before anyone else does, because the mods get it before anyone else does. They put in so much work behind the scenes that you guys just don't get to see often. So I want them to celebrate. So I've got them some stuff and I got to get mailed out. I have a lot of things to mail. I have boxes of pens that were supposed to go out weeks ago that I just have not sat in front of USPS and typed in all the different addresses where these things need to be sent.
That's nicer than I am. I haven't sent my merch to my mods, unfortunately.
Billy's Momzilla, there's a comment on you, my friend. We tried supervising Ian last Friday, but it was hard to adult. Sorry. I don't cast blame or aspersions. M169, happy Friday. Leo's growing fast. He's a charmer. He is, and that's problematic. Dr. Moo is a dude, Rob. I'm sorry. Dr. Moo is a dude. Please check out Dr. Moo's GoFundMe is being posted in the chat. I am sorry. I go by screen names, and honestly, channel metrics a lot, because channel metrics, a lot of you are female, and I apologize that I ever make that assumption. I never intend to. I really don't. But screen names are difficult sometimes. So please check out Dr. Moo.
I made this.
Pigeon business. I love this. I only wish it was the pigeons with the drugs in the backpack. That was
It's
a better
got a backpack.
story. I know it does. I love it. I love it. It needs the backpack, and it's doing pigeon business.
I've got a backpack version. I've got a non-backpack version, but yes, there's definitely a backpack version for pigeon business. So
yeah. Red pen. Rob, we quote built something this week. Yes.
Ooh.
Beautiful live edge bench for my newly remodeled bathroom. Did the paneling too. Thought of you the whole time. Thank you. Thank you for sharing that. That is so freaking cool. One of the favorite things I ever see is when people make comments that they took that advice, go build something, you'll feel better, and they actually do it, and how happy they are. And when they share what they have made, it just makes me giddy from ear to ear all the time.
I need to get back into the leather workshop more often.
Oh, I do too. I think I owe the members and members only. That's been well overdue. And if we do get snow and I have power, I'm not promising, but I will try for the weekend.
Oh, there's like an $8,000 leather or laser that I want. And
the X tool.
That wasn't the one, but maybe I'll have to check that one out as well. But it apparently can cut leather. So I'm just like, I want so bad. So
Ian, I need 1 second to go stop a beeping. Can you keep the people occupied for a second?
I can, but it might be through mischief.
No.
So all right, chat. I can't be too terrible. I saw some people asking about Mrs. Runkle. She still has a cough, and I have a cough as well. And Mrs. Runkle has been keeping me from sleeping, but she's going out camping, so she's away now, which means that I'm actually going to get some sleep, and that is that's going to be good. But I do hope she gets better. I do hope she gets better. Somebody says, "How do I like my prime minister?" Not at all. Trudeau is terrible. So I could go on a rant about that, but then Rob would come back and he'd be like, "Runkle, what are you doing to my channel?" So we're not going to do that. But yeah.
You were close, though. You were really close, though.
I wasn't, but yeah. Yeah.
Mama Vets. Yeah. What a wonderful super chat. Thanks for encouraging us makers. Landed a teaching gig at a local cultural arts center. Cheers. That is amazing news. That's awesome. I think one of the coolest things that you can do is teach people a skill. Teach them a skill. Let them have fun.
Ooh, I can show you guys something. 1 second.
And a great one. Nancy Robbins, who's been so supportive of the channel. Hi, Robin. Ian, thanks for being here. I started chemo last week, and y'all bring joy into this world. May you kick cancer's ass into the next dimension, because I think we can all agree F cancer. And I know chemo is tough. I hope that you can find the light in any single day that you are going through that. But keep fighting. Never give up. Ever. Always fight the fight. So thank you for sharing that, Nancy Robbins. Very kind of you. And good luck. You're going to kill it. I know. You're going to kill the chemo. Kill the chemo. Or kill the cancer. Every single one of those cells. Gone. I want a chat when you're in remission. Because I know you will be. People saying, hi, Mom. Hi, Mom. Oh, and Mom said, hi back. Hey, Mom, don't send me money. Don't send me money. Thank you, Mom. So let me do this. I'm going to roll the intro, and then I want to get into the topic that I did not have on the banner, but I just want to cover it briefly. So intro, and then I'll be right back. Ooh, wait, show that first. What is that? Is that a collar?
So this is something I made for Zora. And so this, is that not beautiful?
Wow.
Guess how long she was wearing it?
I don't know.
About 10 minutes before she did that.
No. I don't see footage, and therefore I view those statements as defamatory. That's if you are afforded the opportunity to prosecute the case, I hope you don't prove the case.
I've got to make another of these out of thicker leather. But I mean, a lot of work went into this. And
so put it close, put it really close to the because wow.
So that's all hand tooled, hand painted. Yeah.
Did you get your airbrushing?
That wasn't airbrush. That's all hand painted with a brush. And it's got a tag with their name on it. I'm covering it because it's also got my phone number. But yeah, it took her all of 10 minutes to just she's like, nope, burst. It was like, we're gonna make you another one.
If we're being critical here, if we're being sincere, I would say that you, the manufacturer, that's manufacturer's defect. You knew the dog that you were manufacturing that collar for.
I thought she was not as destructive as she turned out to be. So this was made out of fairly thin leather. The next version is going to be made out of basically the thickest leather known to society. And yeah, it's hopefully it'll hold her for a bit, but yeah, I also need to just make some belts or something, just do some things. So
it'll make you feel better. You know it will. I know it will. Lisa R here is echoing that as well. Thank you, Lisa. Thanks for encouraging people to make things. I've been stressed at work and took up crochet in the past couple of weeks. My mental health is improving. That right there is huge. And that's one of the reasons I love being on this platform, because I get to celebrate the people who decide they want to go make some fun stuff. So let's roll the intro and then get into some topics. Okay. So the first topic was one that I really didn't think I was going to cover, but there are two truths about me that I think I echo quite frequently on this channel.
Two
One,
truths and a lie. Go.
well, two truths and a lie. I hate all politicians, and therefore I can't follow politics that well. Like, I follow it, but I hate politicians of every variety. I hate the miniature cones, the ice cream cones. I hate the miniature ice cream cones of the chocolate and the I hate those. I despise those. And I love courtroom theater more than anything in the world.
All right.
Pretty good?
Yep.
Okay.
I'm debating now whether I should move into my garage with my leatherwork setup.
It's possible. So you can do that, but I would caution you that you should probably stick around for a minute, because one of the things that happened this week that I could not turn away from, just for the courtroom theater, not talking about the substance of the allegations, not talking about the person, not talking about any of the people. What I'm talking about is courtroom antics and the theater. And there is one of my biggest, every lawyer thinks that they want to have a lawyer on the stand, right? Every lawyer thinks, I want to cross-examine this lawyer on the stand. False. You never really want that. That is the hardest witness to manage. It's the most impossible situation to manage that witness. And I can only think of a judge as being the person who, well, any judge would probably hate more than anything having a bunch of lawyers trying to examine a lawyer. Just
I mean, it depends on the lawyer.
It does.
Because if you're talking about Fani or whatever,
Fani,
she did a great job on herself.
This is probably one of the wildest things that people don't get to see ever. Let me give you some context, some background to this. This is in Georgia, and it involves the prosecution of a former sitting president under a Georgia state RICO statute. We're not opining on the case. I'm not going anywhere near the facts of the case. I don't like it. I hate it. I hate all of it. I don't want to talk about it. However, the litigants in cases, I believe, are always one of those things where we can learn from it. One of the litigants in the case is this Fani Willis. Fani Willis is the elected DA for Fulton County, Georgia. And when you have a major case, it is not uncommon and rather frequent that elected DAs will seek out special prosecutors. Your office is not staffed up to take on big cases like this. So you have to find outside resources. And when you have a RICO case, you have a case against multiple defendants. It's a spoken wheel argument, basically, that there's some enterprise, and each one of those defendants, by having a common knowledge, are tied to every act in the enterprise. So one of the caveats to that is that every one of these defendants has the entitlement to a lawyer. And when you bring a prosecution like this, the lawyers that they bring to bear are not overburdened in their caseload. I mean to say that these lawyers are, all of them, very capable and very smart. And that sets up the stage for this motion to disqualify. So Fani Willis was proceeding with this prosecution, and there's an allegation that the special prosecutor that she appointed was someone that she had a relationship with prior to the appointment. And that becomes a big problem because of the appearance of impropriety. You don't want any of that on the prosecutor's side, ever. And there's a financial stake here because the state is funding the prosecution. The states fund every prosecution. So what you get is the possibility of the elected DA, and I say possibility, the elected DA who can cherry pick to whom she bestows that honor. And if that person happens to have a relationship with the DA, prior to that, there's the appearance of favoritism, the appearance of selection. And when the money is flowing from the state into this person's pocket, there's the possibility that that person with a prior relationship might spend that money on something that you would benefit from. So you are benefiting financially from the task of your office. It's a problem. It's a problem. And yes, I say Fani. That's the way her dad pronounces it. That's what she pronounces it. So I'm going to respect that. So now you have a motion to disqualify. And when I say courtroom theater, you have, I think, 8 or 9 attorneys on the defendant's side. You have the prosecutor's office, and then you have independent counsel hired for each of the DAs that are being questioned here. Fani Willis, the elected DA, and who has her own independent attorney, and the special counsel who has his own independent attorney. And lo and behold, one of the people that gets questioned is the divorce attorney for special counsel, who also has his own attorney. Are you getting the gist here? It's a courtroom full of attorneys, and they hate each other. Every one of them.
They shouldn't. I mean,
shouldn't.
The job really shouldn't be about hating the other lawyer, because ultimately you're just lawyering, right? And I've got great friends who are Crown prosecutors. I have great friends who I've run really contentious trials against, and we walk away and it's like, yeah, we're good friends. It just is what it is.
Yeah. And I want to be clear here. I'm not talking about the case. I don't know the merits of the case at all. All I know is what I saw take place this week in court with this hearing. So I'm talking about this hearing and the courtroom shenanigans and the theater. So everyone has an attorney, and everyone is an attorney. So the attorneys have attorneys, and the attorneys are testifying, and the attorneys are cross-examining the attorneys, and the judge is going, my God, this is my worst nightmare. Because holy crap. So Fani Willis has appointed, I think Nathan Wade is his name. Nathan Wade is a special prosecutor. Nathan Wade gets up and is testifying to when the relationship began, because the argument from the prosecutor's office is that the relationship began after the appointment was made, right? So after the appointment's made, relationship begins, and at that point in time, there's really not really an appearance of impropriety. You haven't done anything bad. Okay, fine.
I mean, still keep everything in your pants, and this is just wait for your trial to be done.
Like, why are you doing this? When I've told other lawyers in my office like about this, and every single one of them, the reaction is like the head smack. Like, are you kidding me?
It's so unnecessary. You're just creating problems for yourself that you don't.
So this is a motion to disqualify. And what people don't realize, well, what a lot of people are now realizing is a motion to disqualify the elected DA is essentially disqualifying the entire DA's office, which means that the attorney general, I believe, in this state has to go out and reappoint a new DA to begin the prosecution after years of investigation, depositions, arguments, etc. So this isn't just a stick in the spokes. This is a freaking landmine. It is wild. So that's some of the context to this. Now, Nathan Wade takes the stand and is testifying to the relationship and saying it began afterwards, and I didn't use any of the money that was given to me from the prosecution of the case to benefit Fani. And there's allegations that are corroborated by both documents being credit card statements and by third parties that said their trips, they traveled. And he makes the contention that says, and this is what got my ears perked up because divorce lawyer. He makes a contention that he put the money on credit card and she paid him back. And she paid him back for everything. So she didn't receive a benefit. She paid him back for everything. This is travel that costs thousands of dollars. Well, how did she pay him back? Well, they were all in cash. Oh, I've seen this argument before a couple of times in divorce cases. And Nathan Wade's testimony, we'll just say this, went so horribly that Fani Willis's attorney, the DA's office, had been fighting the subpoena to get her to testify. They had been fighting it left, right, and center. No, she's not going to testify. She's not going to testify. She's not going to testify. You have no right to get her to testify. And I think they were kind of winning that argument. But
didn't she volunteer to testify?
Well, that's
didn't
where
she stand up and say, "I'm going to testify"?
Nope. This is where we go. So this is one of the defense attorneys who are bringing this motion. And by the way, the format of this hearing, this is another reason why it's so nuts. Let me pull this down for a second. This is being brought by one of the defendant's attorneys. One of the defense attorneys says, I see this motion disqualify. And every defense counsel has a right to participate in this motion to disqualify. They don't have to elect one of them. They all have independent rights to defend their clients. And their clients have independent rights to be heard. So what you have is you have a lead defense counsel who is the first one asking the questions.
You have the gongiest of shows.
Well, and then the judge goes, by a show of hands, who has additional questions. Every defense attorney. I want a chance. I want a chance. I want a chance. So you go through all 8 of them, and then the DA's office gets up, and then now you get redirected. It has been a show unlike anything I have had the opportunity to see. And I say that having witnessed some trials like Murdoch, like Sarah Boone, like what are they? Some other wild ones, Johnny Depp, Amber Heard. This is just nuts. So by all appearances, Fani Willis might not have to testify, but she wasn't having it.
As we've gotten through Mr. Wade, of his faults.
Oh, hang on. I got to boost the volume on this. Boost.
Yeah, it's like show of hands, and suddenly every defense counsel is like a Hindu god with like multiple arms going up.
Interrogatory, serious business for a lawyer or anybody, and then suddenly he's changing. She files her financial declarations.
Now, I'm no body language expert, but
it's okay. No one is.
No one is. But when Spidey, behavioral art Spidey, is texting me going, "Who the hell is Fani Willis, and why is everyone sending me the video?" Said, "Oh, do I have something for you?" Just observe the body language. It was like, I'm not doing this. We're not doing this.
This false interrogatory, serious business for a lawyer or anybody, and then suddenly he's changing. She files her financial declarations. Same problem. We need her in here to go over all of this and to explain exactly what happened. So he was asked the court that
she is breathing heavy. She came in hot. She tossed that thing on the desk and has the hand on the hip. You don't have to be a body language analyst to realize, oh, she's ready to fight.
Yeah, and she's dumb is the problem, because if you're this pissed off, you're about to get clowned.
Ms. Willis. So, Ms. Cross, I don't know if you want to speak with Ms. Willis now. It's sounding like maybe they're withdrawing the objection to the motion.
I believe the motion to...
Or does Ms. Willis want to take the lead here?
We'll withdraw the motion to quash Ms. Willis based on the...
Okay, so...
I'm ready to go.
position of the district attorney at this point is that she's no longer contesting the subpoena. Ms. Merchant has called her as the next witness.
I would ask, I need 3 documents in front of me, and they're the 3 filings of Ms. Merchant. 3 filings.
I don't think I've ever seen a witness walk to the witness stand like that. Like,
I haven't. It's never
jeez.
ended well.
This is one of those things where I caution all of my clients to take a second, try to take the emotion out of what you are doing. Just take a second, step back.
Oh, that's not how she's going to roll here at all.
Yeah, and this was just, she came in hot. And it was, I need 3 documents before I start. Before she even sits, before she's sworn, she says she needs the documents. Now, if you are trying to convince me that she did not watch any of the prior testimony or had any knowledge of the prior testimony, I just quite frankly am not going to.
I mean, of course she did.
She saw the shit show and she was like, I got to clear this up. But she came in hot. And remember how I said you don't want a lawyer on the stand? Like, you think you do, but you don't.
No, you do sometimes.
You do and you don't. Like, I think that she forgot that her place was as a witness. The judge let her roll with it a bit. She is the elected DA. She shouldn't.
Oh,
be
have
in
you
that
seen the
seat.
Janet stuff?
I have.
Speaking of forgetting that your role as a witness.
Every single time that I think I've seen everything, I get shocked.
There are more things than heaven and earth than you can imagine, Horatio.
Does anyone have the 3 filings of Ms. Merchant? Does the court have the 3 filings of Ms. Merchant?
When you say the filing,
I was fine with her saying, does anyone have the 3 filings? Don't look at the judge like the judge is, like you can tell the judge what to do. Now, the judge is, I will say, his judicial temperament. This is a lot of ego to manage. This is what I said. This is a whole lot of ego in one courtroom. There is not enough space to cram all that ego. Like, the fact that all of their heads could fit in that courtroom at one time. Everyone.
I mean, I don't know that they're all fitting at one time, but it's a good notion. It's a good idea that.
you mean like the pleadings?
The pleadings, yes, Your Honor.
Okay. I think we can locate those for you in the supplemental.
I want the one filed on January the 8th, the one filed immediately after we filed ours, and the final one.
If you want to take a break to get them, I can make a copy. I think we have one.
You know, the only copy I have is going to have my notes on it. So if we don't have a clean copy,
Have a 5-minute break during
Let's
all get
take-
the documents.
all right.
I'll sit here and wait for him.
I have a new commandment. Thou shalt not testify while upset. Like,
I mean, I think that she should testify while upset, but that's only because it's funny.
either way, it led to 2 hours of some of the most painful back and forths I think I've ever seen. And it was just wild. And the attorneys were trying to score points. She was trying to score points. I think at the end of the day, I don't think she comported herself how she, in retrospect, I don't think she would have done this. And I know that for a fact because she was scheduled to be on today and testify, and she didn't. They basically said, we don't have any additional questions for her because this was emotional testimony. This was emotional, and it was emotional, but not in the way that you would want it to be emotional. It was a cluster. And the entire hearing so far has been just beyond wild. I don't know that I've ever seen anything like this before.
Welcome
And I
to
don't
the
have a
shit
dog in
show.
this fight. Yeah, I don't have a dog in this fight, and I don't really care. I just think that this is wild. You have back and forth with the attorneys yelling at each other. I'm trying to find the right moment because there was one in particular where was it? Do. 1 second.
Sorry, no more seconds. You're out of seconds.
I'm never out of seconds.
Out of seconds. Sorry.
It's not fair. Don't do that. You never ever want to see anyone fighting with the attorney.
You know,
I do. I mean, I'm the
saying
defense
no good
lawyer. I
deeds
want
for
the
and,
I want the
she
prosecution's
betrayed our friendship.
witness fighting with me.
Down the timeline now. So my questions are going to be from the time period of 2019 until she no longer was employed for you, the last time you all talked. So all of my next questions are just focused on that time frame, okay?
Yes, ma'am.
Up until she left your office.
Yes, ma'am.
During 2019, you all were friends, correct?
Yes, we knew each other in 2019.
During 2020, you all were friends, correct?
We were friends during that time period.
During 2021, you all were friends, correct?
Yes.
And such good friends that when you needed a place to stay, you asked her if you could take over her lease.
That's a lie.
You did
That's
not
not
move
the-
into her apartment?
I
or her
did, but
condo?
that's not the way you characterize it. Is wrong.
I asked if you could take over her lease.
I did not ask if I could take over her lease.
Did you move into her apartment?
I moved into her condo in April of 21. The circumstances around that were that Robin met her husband. They wanted to move into another and separate place. She wanted to get rid of her condo. My father was living with me at the house. Because of this case and because of my stance on gangs, my life was being threatened regularly. My father urged me to leave our home. At the same time, as luck would have it, Robin wanted to give up her lease because she wanted to move in with this new man she met, who eventually became her husband. And so, as life circumstances worked, my dad was begging me to leave the house. He was afraid for me, afraid for his grandchildren. She wanted someone to take over her lease so that she didn't, have to pay a fee or get abandoned. And so I don't remember when, but probably March or April of 21, I moved in and take over her lease.
And did you pay her or did you pay the leasing agent?
No, I don't even know who the leasing agent was. I paid her.
You paid her. Did you pay her cash or did you use the card?
There were some times that I would give her cash, but mostly I paid her via Cash App. That would be the most convenient thing. So I would not only give her rent, but then like when the utilities would come in, whatever the utility was, she might be like, I need $70, I need $100, whatever it was. And we never had a problem with money. Whatever she told me it was, I never asked to see a bill. I never questioned her. I just gave it to her.
What percentage would you say you paid cash versus Cash App?
Oh, the vast majority was Cash App. I don't know what percentage. I'm not going to guess that. But the vast majority was Cash App. But there would be times she would say, this bill came in at $70. It was $70.
Did you have a monthly rent amount that you paid her?
I can't remember. It was $1,500. I can't remember what it was. And it would vary, which I don't understand to this day. But like I said, I never questioned her.
When did you move out?
Cash right now.
Which I don't understand to this day. It's like
$2,500 when we went to Belize.
That's
We
curious.
went to one hotel and then we went to a second hotel. That $2,500 I actually gave him while we were still in Belize. I know that the Aruba trip, the one that you described with his mom, I think I gave him about $2,000 for that trip for like total.
His mom went to Aruba with you?
The Aruba trip. So I consider that to be one trip. So we got off of a cruise ship and then we went to Aruba, which is why I cannot remember is that the time that we had to stay in Miami to wait for the flight for Aruba. So I consider that one trip, but we didn't like come back to Atlanta and leave. We flew down to Miami. We got on a cruise ship. We spent a couple of days with his mama. We came back to Miami. When we came back to Miami, either that day or the next day, we flew to Aruba. We spent a few days in Aruba and we came back. That was really one trip. Even though we went two places, it was one trip.
So let's talk about the California trip.
Now,
Is that when you were moving your daughter out to California? When you all went, or did you have 2 trips to California?
my daughter doesn't live in California.
Did she ever live in California?
I'm not discussing to you the location of my child.
So how many times did you go with Mr. Wade?
You're under oath.
Once.
It was this, like, back and forth. What I'm trying to find is a specific one where she gets into it on the lies. She goes back and forth on the lies. Lawyers make bad witnesses. They just do, because it's combative. It doesn't achieve anything. They act like children.
This is not really fair. I've watched lots of lawyers who were just fine as witnesses. She's a bad witness.
I get that she's mad. I really do. And I get the points that she's making. I get some of the points she's trying to make, like that they're trying to make a mountain out of a molehill. The thing is, the molehill is actually a mountain. Like, it's like, these are big issues here. Like, please stop minimizing. Please stop being combative and minimizing them. Like, actually answer the questions being asked of you. Don't use them as an opportunity to run off on a monologue, but every lawyer is going to try and do that. It was wild, and every lawyer wants their pound of flesh. So they're all going after it. So hang on. There we go. One more clip.
Of my retirement, and that money ended up being lost. And I know when you bet on yourself, you're going to have to bet money on yourself. And so what I was talking about was not wanting to go through the personal financial expense of running for office. By no means did I think that I was going to be financially in a bad position once I won. Let's talk about what I was up against, because it's important to understand that comment. I had a district attorney who had been here for 24 years. People, no, it's very relevant as to what my mindset was about this. So I'm
Yeah, but
trying
it's
to
not the
answer your
question you were asked. So
what I was saying is
Taylor, so it's a finance.
right, but it is about my finances. If I didn't, nobody put me in this seat. So I had already run for office once. I had spent $50,000 of my own money running, and it was vamoose, nothing. And so when I'm talking to those offers, I'm talking about the contemplation of the sacrifice of the run, not the sacrifice of once you become DA. The odds were against me. I was likely going to lose the election based on who I was running against. So that needs to be in the appropriate context.
Isn't it true that the authors also wrote, and you can dispute this if you'd like, that you were broke after that race?
The 2018 race.
Yes.
Yeah, that was a hard race. I wasn't broke like I didn't have any. So broke is relative to depending where you are, but that hurt to lose that $50,000. So I'm sure my mental mindset was like, I just gave $50,000 away.
Right. So they characterized it from their conversations with you that you were broke, you had poured your own money into the campaign, and you weren't able to pay your own bills because of your clients couldn't pay their bills to you, and you had a paltry array of family and asset forfeiture cases. It says you were trying to make it month to month. Is that an accurate depiction of your financial situation at that point?
going broke as a lawyer is much worse
but
than going broke
I don't remember clients not
as
being
anyone
able to
else,
pay
by
their
the by.
bills, or-
May I approach Trish?
You can.
You may.
Because there's all sorts of ethical
I have not read
issues
this
that
book.
come up when you go broke as a lawyer.
Wait, sorry, it was this part. I wanted this part. She goes, "Can I approach?" Come on.
I have not read this book. Okay.
You may.
I don't remember clients not being able to pay their bills, or
May I approach Trish?
you can.
You may.
Page 14.
Tell me you caught that. She goes, "May I approach?" Who answers? Like,
I
you
missed that.
can. Did you catch it?
Oh, she answers that?
No, hang on. Watch this one more time. This is just part of the dynamics.
So
May I approach Trish?
you can.
You may.
Page 14.
That's what I'm talking about. This is why you don't testify emotionally. This is why you don't do this. Like you if you're going in there hot and you have something to prove, maybe you should take a beat.
I don't know.
I don't know where this is going. I don't care where it's going. Yesterday was a cluster.
I know where it's
Today was a
going.
cluster. You have lawyers that are, well,
I mean, this plane, where it's going, it's landing midway through that mountain.
but the judge is sitting here parsing through all of this and trying to decide how they're going to handle it. And the judge needed to have better control of his courtroom. But I will, in the judge's defense, I'm going to say that's a whole lot of ego to rein in. Like, that's a lot. And you're a judge towards the end of the day, you're exhausted. You're like, oh God, I can't deal with this shit anymore. These fucking lawyers. And you're just going nuts. But it was so wild. And people are saying I'm confused. The judge answered, no. She goes, you can, and then looks up at the judge for him to echo. It was just wild. And then today they were parsing through all of the litigation, or all the arguments of privilege and what's privileged and confidential, and they were trying to ask questions. It was legal jousting like you don't get to see very often. So there's very fascinating aspects to this. So I'm not going to cover it that much. I just wanted to go into it briefly to say this is a circus. And if you are ever interested in courtroom theater, yeah, you can go check it out. This is
not so much theater as it is, circus, monkeys. This is one of those times when it's like, I'm glad this is not my circus, not my monkeys. And I don't have to wrangle the fleas, because a whole lot of people are going to find that if you go and you wrestle with monkeys, all you get is bitten and fleas and all of that. So
yeah, that's for damn sure. Like you get into this and it's what you get. I mean, this is part of it. So that was that little segment. And then we'll go to a funny, let's swoop to something funny before we cover the other stuff. Cleansing swoop. It's been 2 weeks, but I still remember how to do the swoop. So the texting judge in Oklahoma.
oh, she done.
Mm-hmm. She def done.
Over and out.
So for those of you who don't remember, there was a judge in Oklahoma who was alleged to have been texting her bailiff, other people, inappropriate things during the course of a trial involving the death of a child. And then she was like, no, I didn't. And then she moved the camera and she did back and forth in the pink chairs and all the above. Well, this judge.
Now remind me, is that a good time to be accused of texting, or a bad time?
Oh, it's a bad time. It's a bad time. And it was like several texts. So she has now basically said, I agree to not be a judge anymore.
Ever.
Because that was the smart thing. State of Oklahoma versus Tracy Soderstrom. Settlement stipulation request for order of approval and final order of dismissal. Ian, it's your favorite line. You want to read it?
Comes now.
Go on.
Not even breathing hard. Matt K. Martin and Amber B. Martin, attorneys for petitioner appointed by this court, and District Judge Tracy L. Soderstrom, with counsel Tracy E. Schumacher and William Wells, and respectfully request this court accept the settlement stipulation, enter an order of approval of the settlement stipulation, and enter a final order of dismissal of this matter. In support of these requests, the petitioner and respondent state as follows.
So October 10th, petitioner.
One day I'll get the money to make that video to end the comes now.
I know you will. Because you know what? If you're not behaving like a child, are we really living anymore? Because I do it too. The state of Oklahoma Chief Justice, and remind everyone in the chat, this original petition was brought by the Chief Justice of the Supreme Court of the state of Oklahoma. When you have someone who's saying, hey, you ain't qualified to be on the bench, the last person you want making that statement is the Chief Justice of the Supreme Court of the state where you preside. So the petition has been amended twice, and the second amendment petition is the operative petition. The second amended petition alleges that the respondent engaged in certain conduct prohibited by the Oklahoma Constitution. The respondent filed an answer to the second amended petition containing her admissions and denials to said allegations. She denied like everything. It was really kind of ridiculous. Also, on October 10th, this court entered an order convening the court on Judiciary Trial Division.
Denying everything is what you do.
You do. But she also shot back like a couple different ways.
The number of lawsuits you'll see where the response is just, we deny that plaintiff exists. If plaintiff exists, we deny that they've ever met the defense. If they have met, then we deny that they just deny everything.
We deny that they knew they met.
Yeah.
All of the above.
I've quite literally seen they start off with like paragraph 1 is like, plaintiff is a resident of, the state of New York. And they're like, we don't have sufficient information to confirm or deny. Like, just yield that the person lives where they say they live, right? Unless you got some reason to.
Yeah. So in order to resolve the matter, the respondent, the judge, texting judge, has voluntarily decided to resign as district judge for that judicial district. Effective upon entry of the final order, this matter will be do so by 5 p.m. on February 9th, so no longer a judge. She acknowledges application of Title 20 and will not again seek any judicial application or judicial position in the state of Oklahoma, so she ain't ever going to be a judge again. She waives the right to appeal any action or decision of this court to any count, including but not limited to the Supreme Court, and then the petitioner will seek dismissal of the matter. Please accept this settlement. Respondent represents and declares that. So the texting judge, declares that in executing the settlement stipulation, she relied solely upon her own judgment, belief, and knowledge, and the advice and recommendation of her own independent selected counsel concerning the nature, extent, and duration of her rights. Claims and that she has not been influenced to any extent whatsoever in executing the same by any representation or statements. She's carefully read it, yada, yada. So she gone. She ain't going to ever be a judge again. And you know what? We say we haven't been astounded by a lot of things. This was one that kind of caught both of us really off guard. Like, she was sending some really inappropriate shit. Like, terrible.
Yeah. Like, ought to have known better.
Got Debbie Davis in the chat, prosecutor.
So, hey.
Hanging out. Yeah, that one was a little bit, that confounded me, because why you are a prosecutor making comments about your bail, about the
why you're a judge, you mean
law enforcement, or why you're a judge making comments about
you were getting Debbie confused there with
but making comments about the
Debbie Davis, we should be clear, not the person involved in this.
No, in no way, shape, or form. Making male attorneys, bailiffs, etc., sit on a pink chair so you can take photos and put them in your chambers for some reason, and then texting throughout the duration of a trial, opining on the appearance of counsel. I mean, not really a good look for a judge. Just saying. Not the best. You don't really want it. I want to catch up on some of these before they become out of context, super chats wise. Oh my gosh, there was a lot. I'm sorry, guys. I wasn't looking at the chat for a second. And I ran.
Oh, look at Rob. His big problems of too many super chats.
Ian.
I have to tease you.
I know you do. Finally, free judge doesn't read any of my attorney's briefs or local rules, procedure, and evidence, clearing the docket. Unchallenged incumbents, shit results one day. I hope the truth will succeed, even if not in court. Yeah, judges tell you not to sling mud, but then they give credence to the lawyers who sling mud. And I hate that. So I try to stay above board, and I just try to advocate more and more and more. And I try to incorporate tricks I learned along the way. It's not fun. Court is a pain in the ass. Canonical Heat. I'm late, but you all should do the YouTube things and appreciate the fantastic mods. Mods are fantastic. You guys, if you wouldn't mind liking the stream, it does help a lot. Please like the stream. Go follow Ian. Ian and I are really good friends. We have a lot of fun together, joking, laughing. Ian makes inappropriate remarks. I try to keep him on time and on task, and he tries to do the same with me. We fail often.
You seem to end up with a lot of mischief in your life. So
there's a lot. There's a lot. Bama Girl in 1955, nothing like good old Southern lawyering. There was a lot of accents that were a lot of fun to listen to. Boppet sent you a DM on X. Okay to share. Okay, Boppet, I'll take a look at that. Let me see. Where are we? I can't call it X right now. It drives me nuts to try and do that.
yeah, no, it's not X.
It's still Twitter. Oh, it's a bumper picture.
X can go into the same category as comes now.
So that's the stand for the Rikon jointer, and that is Boppet, the pupper, who's sitting there. And you can see that they've got a cup, the Law Nerd cup, Emily's cup, I think, in the back. That's really cool. That's awesome. That makes me happy. Thanks for sharing that, Boppet. Shiraz gifted memberships. Thank you very much. Mama Bear, attorneys who have attorneys who are attorneys who have attorneys. That is the definition of that trial. And when you talk about chaos, there is no chaos like that level of chaos. It is wild. Haley's comment, she came in like a wrecking ball. I don't think she was wearing her dress backwards.
No, that was not wearing it backwards.
I think that was wearing it properly. And I don't hate the pink. Honestly, I think it was a good color. I don't hate her. I don't hate anyone in that trial. I just laugh at the fact that it's taking place.
I just hate everyone.
Principal Potato. Can we take a moment to look at her lawyer's face that just screams, oh shit? Everyone in that courtroom collectively, I think, had an oh shit moment when she came in there and threw her hand on her hip. It was like, I'm going to testify. It was like,
yeah, I think mostly it was her lawyer.
It was, yeah, just like, oh shit. GQ made my first quilt for nephew entering the Navy at 18 as an officer. Congratulations. I made something. It made me feel better. That is fucking awesome. That's so cool. Gotcha. I'm usually painting or collaging while watching FNF. It's quiet, 3:30 a.m. over here using headphones, and it helps me work more intuitively while my mind is occupied with funny law stuff. Thank you for keeping me company. Gotcha. That is awesome. I put Ian on when I'm in the shop. I put Emily on. I put Rick on. I put Kurt on. I put all these people, Niklas, Danny. If there's a voice that's talking about a case, I like having them in my ear while I'm working because it's like having company in the shop. DK Cripple, Fani's dress was on backwards. I don't think it was, and I can't unsee it. You can have that opinion. I don't think it was.
I don't think it was on backwards. I think it was just that it has a front zip.
Yeah, I think it did. Victor Man 7777. Did you see the prosecution on Destroyed Bailey after it appeared he had been testifying in their favor? Today's testimony and today's hearing was, I watched it. I could not believe it. I will say, if you guys like courtroom drama, go check it out. V. McWilliams, it was a shit show. It was a shit show. Elizabeth Love, thank you. GA law student here. My ethics class devolved into a roast over the obvious ethics issues and how much sympathy we have for the judge with this. That is the one person that I'm going, oh my God. Like every day, the past 2 days, he's going, this is my life. This is my life right now. It's been crazy. BS, unfortunate initials. She pays him cash, no deposits back in the firm, no paper trail of cash. Hope IRS is watching this trial. There were problems in a lot of the testimony.
I'm just going to say, like, cash payments are freaking risky because the number of circumstances where people are like, oh yeah, I made cash payments. And it's like, did you? Or, oh, I get paid in cash for my work. It's like, do you, or are you just like doing a fraud? Because those are different things. And
It is. It's one of those things where there are things that we can do, and then there are things that we as lawyers should know better to do. Things we can do. I can easily pay cash for a lot of things. I can easily write stuff off. I can easily just say, no big deal. But you, especially when you're prosecuting a case like this, one of the things that was kind of just shocking to me was when you are prosecuting a case like this, create and recognize that this is going to be subject to scrutiny. You know it's going to be subject to scrutiny.
You know the other side is going to be throwing every bit of mud and stick and, everything that they can at you. So don't sit there giving them the ammunition yourself. Like
now,
let them find their own ammo. You don't need to make it for them.
I also tell people that in my cases of dealing with child support and spouse support, alimony or child support, right? If you're making those payments, do not pay in cash.
Yeah, ever.
Pay by check or pay by some transfer that has the ability to give a memo. Now, there's a caveat to that. In the memo line, be careful what you write.
Do not put any of the things you are thinking of putting down.
Yes, ever.
Because lots of people have these clever notions of what they're going to write. Like, to, and then some elaborate descriptor of their partner.
Mm-hmm.
That's a popular one.
Yeah, don't do that.
I have seen people put down things like you write a check to somebody and you put down for sexual services or something like that. Don't do that.
No.
For two reasons. One, the old notion was that people would be too embarrassed to go cash it. And the problem is that now people just do photo check cashing. Or they just put it in at the ATM and nobody ever sees it. Like, you're not cashing things in front of a teller now, so nobody cares. It's
the law does not handle jokes well. It never has, and I don't think it ever will. So that's just one of the reasons why you don't want to do that. Adrian Angevine, thank you. Joe someone caught and told Joe Fani was wearing her dress backwards. I don't think it was. If you can't,
I don't think so.
Shelf, you're to start after wrong. I don't think it was. I saw people making that comment, and plus, I don't comment on the appearance of the people that are there, except for the fact that her demeanor and her clearly frustrated appearance, that was what I was commenting on.
There was very clear.
She was angry.
Well, no, I mean, talk about her dress. It was very clear that dress was designed to be worn to show, there's features. Yeah, the stitching, it's elaborate stitching. You don't put that elaborate stitching to not be seen, right? Like that. I don't think that holds any water, at least not to me. I look at that and I'm just like, no, that's not what was going on.
Trace Fagan says, didn't she do everyone on the way out and didn't dox everyone on the way out? I don't know. I don't know that fact. I haven't been covering this trial. So, like I said, I was covering the hearing. I commented on the hearing. That's it. Kathy Trout, don't worry, Ian. Leo gets some side eye. Maybe. The friendly CC, glad to be here. Heart you both. Thank you very much. Mary Lou Crafts, just wanted to say making stuff does make everything better. Been struggling upcycling some fabric from some of my grandpa's clothes. Felt awesome. That's one of the really cool things because you can be around that and remember him. And that's an awesome project. Hat chipsets. How? H. Ka. I'm OCD cleaning and finishing my fireplace mantle carving. I did not say your name because I didn't want to be disrespectful by butchering it. Fireplace carving. Awesome. I want to see. Send me a picture, please. Anna I. So when I pay my massage therapist via Venmo PayPal, I shouldn't put torture in the memo line. It's accurate. A lot. Bop it. Darts were in the front, so she was wearing it properly. Awesome. And then K-Rab, when I got my divorce, my ex insisted I keep our joint account so he could use to pay the alimony of without it consisting 15 to transfer the money. I said no. Just you know, there is a thing that the best revenge is a life well lived. I'm just going to say that. The best revenge is a life well lived. You don't have to make a point. Just live your life. So, swoop, and then next topic. So, whoop. So, Ian, I want to talk briefly about McDonald's ice cream.
Sorry,
I know
we
it
can't
sounds-
talk about that. The machine is broken.
Well, it's funny you say that. You're right. So McDonald's ice cream. So this is in 2023, December 14th, right? McDonald's ice cream machine hackers say they found the quote smoking gun that killed their startup. Kitsch, the company that tried to fix McDonald's broken ice cream machines, has unearthed a 3-year-old email that says proves claims of an alleged plot to undermine their business. Well, now I was captivated. Completely captivated.
Have you been
What?
following this one?
I saw a video, and based on that video, I pulled all the pleadings I could find. Everything. This has been a multi-jurisdictional nightmare, resulting in different lawsuits between the manufacturers, the company, McDonald's corporate in various jurisdictions. There has been judgments that were entered in district court that have been appealed. This case is nuts. So
It's bananas.
Well, it's not banana flavored ice cream. A little over 3 years have passed since McDonald's sent out an email to thousands of its restaurant owners around the world that abruptly cut short the future of a 3-person startup called Kitsch. And with it, perhaps one of McDonald's best chances for fixing its famously out of order ice cream machines.
They don't want them fixed.
They don't. They don't. Until then, Kitsch had been selling McDonald's restaurant owners a popular internet-connected gadget. So let me describe it this way. So the ice cream machine is broken. Let me pull this down for a second.
Because it's always broken.
Here is the summary, like broad looking down lens. McDonald's corporate contracts with a manufacturer of the ice cream machines. Okay, so there's a manufacturer called Taylor. It's Taylor Commercial Food Service. And McDonald's corporate says, Taylor Commercial Food Service, you have the exclusive right to sell the machines that manufacture our soft serve ice cream. And you have the exclusive right, McDonald's corporate says, to service those machines. And when I see this, so John Smith, franchisees, not McDonald's corporate, no. So the edict of which machines you can have in your McDonald's comes from corporate, right? You have to have their specific oven, their specific storage.
Yeah, just because you're a franchise doesn't mean that you can start doing things like, hey, our McDonald's offers steak.
Yeah. So this manufacturer is the exclusive producer of all of the ice cream machines in McDonald's. And McDonald's ice cream machines are famously broken, right? They also have the exclusive right to service their machines, order it. Well,
Mrs. Runkle is out, so Chinese food is totally... there's a bunch of things she doesn't like as much. She does not like mushrooms, and so I might order like a mushroom thing.
Do that. I love the play-by-play on the announcing.
I'm still full of mischief. I'm sorry.
I know, it's fun. So here's the thing. Exclusive manufacturer makes the machine, and they reserve the right via their contract to be the exclusive person that services those machines when they go down. Fine. Okay.
And they go down more often than redacted analogy.
Thank you for the redacted analogy comment. Much appreciated. But what ended up happening was a lot of the franchisees started realizing their customers were pissed off and their customers were frustrated that the ice cream machines always seemed to be inoperable. And they had to wait for the service technicians from Taylor Commercial Food Services to go out and fix it. Well,
I think that Taylor must have like one technician across the planet.
they might, until you find out how much Taylor makes on the servicing. So this small group of, not going to say hackers, we're going to say just very smart computer science geeks and nerds, the ones we like, the ones we love. They basically create, how when you go to a car or you go to an auto body shop and you have them plug in your car and the little thing shows what the diagnostic errors are and what you have to do to fix it. So this,
I plug it in.
Startup,
it's like, hey, number 12 error GFY.
Well, yeah, this little startup of ethical hackers is probably the right way of doing it. They don't do anything. They don't actually go in and steal any corporate secrets. They go in and they reverse engineer it. And what they do is they create a product that allows these franchisees to not call in the service to Taylor and to just plug this thing into their ice cream maker. And this then shoots back to them exactly what needs to be replaced. And lo and behold, they can find the part and find someone to install it within minutes. So, who's not happy about this? Taylor.
Yeah, no kidding.
Yeah, no shit. So Taylor gets wind that there are these people that are out there that are doing this, and they need to catch them red-handed. So thus begins a lot of conspiracy and corporate espionage of secret people that go in to try and order ice cream and see if they can talk to the manager about what they use to keep their ice cream machines running, because there's a long known thing that they're always down, for the sole purpose of suing the franchisee for going around the contract.
The other fun thing is that if you have a franchise with either Coke or Pepsi, at some point you may get somebody who comes in, orders a drink from you. They'll order it by name specifically. They'll say, "Can I get a Coke?" And then they will take that drink, put it into a sealed bag, and walk out. And if when they test that drink, it is not their specifications, you are getting in trouble. Although McDonald's actually has permission to run different specifications on their machine than Coke does, or than Coke asks for anyone else. So
going back to the reporting by Wired. Until then, Kitsch had been selling McDonald's restaurant owners a popular internet-connected gadget designed to attach to their notoriously fragile and often broken soft-serve McFlurry dispensers, manufactured by McDonald's equipment partner Taylor. The Kitsch device essentially hacked into the ice cream machine's internals, and when they say hack, they mean
it would just read sensors.
It reads and detects. Monitor the operations and send diagnostic data over the internet to an owner or manager to keep it running. But despite Kitsch's efforts to solve the Golden Arch's intractable ice cream problems, a McDonald's email in November 2020 warned its franchisees not to use Kitsch, stating that it represented a safety hazard for staff. So here's the corporate collusion.
Here's the safety hazard. It's if you use this, we will hit you with a brick. The safety hazard is we know where you live, mother.
Kind of. So Kitsch says its sales dried up practically overnight. Now, after years of litigation, the ice cream hacking entrepreneurs have unearthed evidence that they say shows that Taylor, the soft-serve machine maker, helped engineer McDonald's Kitsch-killing email, kneecapping the startup not because of any safety concern, but in a coordinated effort to undermine a potential competitor. And Taylor's alleged order, as Kitsch now describes it, came all the way from the top. So on Wednesday, Kitch filed a
Extra
newly
spicy.
unredacted-
Please make it hurt.
Oh,
Add to
God.
cart.
You've got food on the way. So Kitch filed a newly unredacted motion for summary adjudication in its lawsuit against Taylor for alleged trade libel, tortious interference, and other claims. The new motion, which replaces a redacted version from August, refers to internal emails Taylor released in the discovery phase of the lawsuit, which were quietly unsealed over the summer. The motion
That
focuses
ice cream cone. That ice cream cone maybe could use like some Viagra.
Oh, God. The motion focuses in particular on one email from Timothy Fitzgerald, the CEO of Taylor Parent Company, that appears to suggest that either Middlebury or McDonald's send a communication to McDonald's franchise owners to dissuade them from using Kitch's device. Quote, not sure if there's anything we can do to slow up the franchise community on the other solution. Not sure what communication from either McDonald's or Mid can or will go out. In their legal filing, the Kitch co-founders, of course, interpret the other solution to mean their product. In fact, Fitzgerald's message was sent in an email thread that included Middlebury's then COO, David Brewer, who had wondered earlier whether Middlebury could instead acquire Kitch. Another Middleby executive responded to Fitzgerald on October 17th to write that Taylor and McDonald's had already met the previous day to discuss sending out a message to franchisees about McDonald's lack of support for Kitch. But Jeremy O'Sullivan, a Kitch co-founder, claims and Kitch argues in its legal motion that Fitzgerald's email nonetheless proves Taylor's intent to hamstring a potential rival. It's the smoking gun, O'Sullivan says of the email. He's plotting our demise. So we have these email blasts back and forth. And
This seems like a food lawsuit that is way better than the cereal lawsuit.
it's pretty good, right? So Kitch has long argued the McDonald's safety warning was bogus. In the complaint, it noted that its device has received certification from Underwriters Labs, an independent product safety nonprofit, including meeting its safety standards. It also countered in any complaint, and he claimed that Kitch's device remote connection to an ice cream machine could result in the machine turning on while a person's hand was inside. God, that was really the claim. In fact, Taylor's own manual advises unplugging the machine before servicing it and removing the door and machine to access the rotating barrels automatically disables its motor. So Kitch goes, here are all the safeguards. Nice.
Yeah, and I mean, anytime you're working on a big freaking machine, unless you really know what you're doing, you're separating it from power. And
well, and good on Wired for reaching out to get comment from the other side and actually doing it, because we get a comment back. So Middleby, Taylor's parent company, issues a comment in response saying, quote, McDonald's decided to issue the November 2020 field brief on its own accord, not at Middleby or Taylor's direction. Okay.
sus.
Taylor stood and continues to stand by the accuracy of statements made in the field brief. Spokesperson also notes that Taylor won an early ruling in the lawsuit against Kitch's request for preliminary injunction, which would have prevented Taylor from developing a device that Kitch claims was copied from its product. So you now have a lot of people throwing mud at one another over broken ice cream machines.
And the ice cream machines are still broken.
Yep. According to the website McBroken, which I now know exists, which is awesome. I'm never not thinking about that, which tracks ice cream machine downtime at McDonald's restaurants across the U.S. between 13% and 17% of McDonald's restaurants have had broken ice cream machines at any given time just this month. That
How
percentage
shitty does your
recently-
product have to be before people are setting up a web page to track how often it's broken?
Literally McBroken. The percentage has recently been as high as 35% in New York City and 28% in Washington, D.C. So this is where we are. Now, let me see if I can't find this one. In addition to this lawsuit against Taylor, Kitch is pursuing a larger lawsuit against McDonald's itself, asking for $900 million in damages for what it describes in its legal complaint as McDonald's effort to drive Kitch out of the marketplace.
So that's like a 0.5% of McDonald's daily profits.
Might be.
It's like
So-
we want permission to go to the McDonald's head office and feel around between the couch cushions and keep what we find. That's what they're suing for here.
Now, one of the things they've been having is jurisdictional issues. Where is it? Here we go. So the case first started in Delaware, and then they said, no, you can't. You have to sue them where they are, which is California. So this, while it says Delaware, this is actually the case that got transferred to California. So this is the complaint by Kitch against McDonald's. And I always love catchy complaints. And when the people do this kind of stuff, complaint, paragraph 1. McDonald's is best known for its world famous burgers, fries, and broken ice cream machines. The problem is so widespread that even the McDonald's communications team has tweeted about the issue.
I love this so much.
Just first paragraph.
Somebody had so much fun drafting this. And the thing is normally, like, there's got to be huge money in fixing these things. And this has got to be like a major source of pulling money out of the franchises back to McDonald's, because otherwise, why? You want a franchise to have a reputation for everything going well. This is, in fact, one of the key advantages of a franchise. Like, if you are anywhere on the planet and you walk into a McDonald's, you know pretty much what you're going to get. I mean, there might be some regional, like they do this kind of burger in this country, but you can probably still get like your chicken McNuggets and your Big Mac and, you know, and the trademark fries, and you're probably going to feel pretty good for 10 minutes, and then you're going to feel like shit once you start to digest it. That's the McDonald's experience, and you can get that
Correct.
anywhere. You want that reliability, that expectation of what you're getting, and instead they're like, it's going to be broken. You can get McDonald's, like you can get ice cream if you're lucky, you know.
Well, and whoever was running the social media account for McDonald's, you think they regret this tweet? We have a joke about our soft serve machine. We have a joke about our soft serve machine, but we're worried it won't work. Thousands of frustrated customers complain about the broken machines, and McDonald's operators are forced to pay for costly repairs and maintenance to keep the machines up and running. Some franchise operators have reported shelling out thousands of dollars per month in service fees to Taylor Company, the manufacturer of the machines, through its many franchised distributors. Despite the widespread issues, McDonald's has failed to meaningfully improve the machines, and the fast food giant has even granted Taylor exclusive rights to supply kitchen appliances to more than 13,000 retail locations in the U.S. This arrangement generates millions of dollars of revenue for Taylor and its network of franchised distributors. McDonald's allows Taylor's monopoly to continue for two reasons. First, independent owner-operators, and not McDonald's itself, pay for Taylor's costly service and repair fees. Second, Taylor develops new commercial kitchen products exclusively for McDonald's. So basically, they are saying, of course you say we have to use this machine. You don't have to pay the cost of servicing it. And on the back end, they're promising to develop stuff for you, exclusively for you. So you get all the benefit and pass all of that on to us, the franchisees.
Yeah.
Ian, can you read the next two paragraphs?
I probably let me just see if I remember how to read. So, this lucrative scheme between McDonald's and Taylor continued uninterrupted for years until a tech startup developed the Kitch solution, a low-cost, data-driven fix for McDonald's broken C602 machines that one McDonald's operator described as very, very, very finicky. Jeremy O'Sullivan and Melissa Nelson co-founded Kitch Incorporated and invented the Kitch solution, an independently developed IoT, so Internet of Things, computer device with proprietary software and an online interface that allows customers to monitor and control soft-serve machines remotely. The Kitch solution retrieves data from McDonald's soft-serve machines, displays it on Kitch's user-friendly interface, and adjusts settings hidden deep in the machines, which can prevent outages before the machines can detect an error. By delivering performance data directly to its customers, predicting errors, and adjusting machine settings, Kitch reduces machine downtime and minimizes the need for costly repair appointments.
And thus, one would think that, you know, as a consumer, we would like this. We would like this. In 2019, Kitch launched a confidential product trial, the Kitch trial, after dedicating significant capital to develop the solution. The product trial allowed Kitch to aggregate and analyze machine hours to create automated adjustments that reduce the machine's downtime. By analyzing this customer data in real time, Kitch developed and fine-tuned a proprietary alert and notification system wildly popular with customers, launching Kitch's rapid market growth and instant success. Well, yeah, you create a thing that says when it's down, when it's working, when it's going to be restored. By contrast, McDonald's and Taylor have spent 20 years attempting to develop their own IoT solution for the broken machines, but the competing market, unlike Kitch's, will not permit users to fix the broken machines, only to monitor them in a limited fashion. Now here's the trick. McDonald's says you got to use this machine. No, you can't touch it. No, you can't mess with it. You have to use it. You can't fix it yourself. You have to go through somebody else. This enables Taylor to retain the revenue from its lucrative repair business. Regardless, McDonald's and Taylor's limited IoT product called Open Kitchen has never launched because Taylor is not a software company and it lacked the know-how. Recognizing Taylor's limitations in April, Taylor's parent company, Middleby Corporation, purchased a tech company called Powerhouse Dynamics to try and modernize Taylor's machines, but these efforts to date have faltered. These tech companies, man, Powerhouse Dynamics, really? The names. By the end of 2018, McDonald's tabled Taylor's proposed solution as premature for its restaurants. So in the interim, we're going to table this as premature. We're not going to let the fix go in. We're just going to say they have to keep calling the service company. The project remained dormant until February of 2020. So basically until Business Insider broke the case, highlighting Kitch's highlighted problems with the machines. The article described Kitch's success and explained that McDonald's operators were relying on the Kitch solution to manage Taylor's finicky machines. The positive coverage about Kitch angered McDonald's. Taylor's CEO described McDonald's leaderships as all hot and heavy about Kitch's success that were described in the article. So the two companies joined forces to drive Kitch out of the marketplace. Oh, conspiracy. Unable to compete fairly with Kitch, McDonald's and Taylor enlisted a group of Kitch trial participants to develop a competing product that would prevent Kitch from fixing the machines. This allegation, let me explain what this actually means. This means that McDonald's and Taylor, this is what the allegation is, not proven, allegation. Instead of saying, hey, Kitch, we'd like to buy your product, or hey, Kitch, why don't we buy your company and have you come on board? Hey, Kitch, we see that you're doing this. Or that was option one, buy them. Option two, hey, this other software company found out how to do it. Why can't we find out how to do it too? Instead, they opted for, they found a way into our machines to say what was wrong with them. Let's prevent them from finding the way into the machines to say what's wrong with them. Like they went and tried to prevent the determination of what was wrong.
I am guessing there's a lot of money in fixing these machines.
Millions. Millions annually.
And that's the thing is at the end of the day, sometimes they want to make sure that you know, that they get. And I mean, the key here is really that we should have laws that actually, we should have right to repair laws that forbid this kind of behavior. Because this is essentially monopolistic, anti-consumer behavior. So
entirely, 100%. I 1000% agree. McDonald's and Taylor's relied on Taylor's franchise
that might be too many percent
to identify. Probably
we're gonna have to check the math. Check his math.
So They relied on Taylor's franchise distributors to identify Kitch's customers and to obtain Kitch's innovative technology. McDonald's and Taylor held bi-weekly meetings devoted to copying Kitch's technology from the Kitch trial participants. Meeting minutes described focus group sessions with Kitch customers and confirmed that Taylor accessed valuable and non-public insights into Kitch's features, user experience, customer preferences, and alert management protocols. Features from Kitch that McDonald's and Taylor admitted we are lacking. So now we're in corporate espionage allegations. They are now, you have McDonald's and a big food product manufacturer engaging in alleged espionage to find out what this other company is doing. Yeah. TFG improperly obtained a physical Kitch solution device from Tyler Gamble in May of 2020, and Gamble provided TFG his login credentials to the KSP the following month. Using this unauthorized access, TFG sent Taylor screen captures depicting password protected portions of the KSP. And McDonald's, Taylor, PHG, and TFG coordinated to add features to Open Kitchen. Oh, so they took the screenshots from this illegal access and used it to add features to the software that Taylor was developing.
I'm surprised that they didn't start doing things like encrypting their bus and so forth, because yeah.
Well, this one is, I like this shade. Despite this insider access to the confidential product trial, McDonald's and Taylor's Open Kitchen could not keep up with Kitch. In mid-October of 2020, after having access to Kitch's solution for months, Open Kitchen was still not ready to be commercialized. Dun, dun, dun. So this is essentially where we are. Let me see if I can't scroll a little bit here. Oh, wait.
I'm now ordering all the Chinese food, so I am going to, you may see me increase in size over the course of this stream.
That's fair. McDonald's and Taylor worked together to create a stall tactic. Together, they fabricated bogus, quote, safety claims to mislead Kitch's customers into believing that safety testing determined that Kitch's solution would cause, quote, serious human injury, end quote, to users, claims that are, and the McDonald's and Taylor both knew at the time to be demonstrably false. Oh, no. Dear operators, we are pleased to share that McDonald's GSSS equipment team, in partnership with the acronyms of these corporate companies, man, it drives me nuts. Important note, we become aware that a few operators may be using unapproved aftermarket technology, Kitch, on their Shake Sunday machine. As a reminder, any operator that is using this aftermarket, quote, add-on to any of their machines, underlined for emphasis, will completely void any existing OEM equipment warranty. Additionally, any machine failures that are associated with the installation of Kitch during or after the warranty expires will be the sole responsibility of the operator, not the OEM supplier. The Kitch device allows complete access to all aspects of the equipment's controller and confidential data, including areas where only certified technicians should have access, creating potential equipment reliability issues without the restaurant's knowledge or ability to stop it. Even more concerning, McDonald's has recently determined that the Kitch device creates a potential very serious safety risk for the crew or technician attempting to clean or repair the machine, given that the Kitch controller may cause the device to change its operating or continue running during cleaning and maintenance in a manner that can cause serious human injury. As such, McDonald's strongly recommends that you remove the Kitch device from any machines and discontinue all use, and is reminding you that any continued use is not approved and is at your sole risk.
Now, were there ever any actual... Yeah.
No. Yeah. First, contrary to the assertions, McDonald's and Taylor have filed sworn declarations that they never tested the Kitch solutions. So they never tested it. They issued that warning, but never tested it. Okay. Second, Intertech, this is the company that signed off on it being safe, Third, Kitch was founded for the very purpose of and has been, in fact, improving the safety and reliability of software-served machines at McDonald's, and they've never received a single report of an injury caused by Kitch Solution. Let me see. Fourth, it integrates the safety mechanisms. Fifth, it gives the user interface complete monitoring and control in real time. And the safeguards are there. Layers of protection.
Now, does McDonald's not have like lockout, tagout procedures for this? Or do they just be like, or is McDonald's just being like, hey, we have minimum wage workers. Who cares if one gets an arm sawed off?
And that's also part, I didn't even think about that, Ian, because this is the same company that, didn't they just settle with, not OSHA, but who'd they settle with? For how many millions of dollars for the injuries for the workers that were underage? And
I don't know, but I mean, one thing people should be aware of, there's a very common injury that happens anywhere there's a deep fryer, which includes McDonald's. And it goes like this. You put the deep fryer thing in, the basket in, and it spatters grease because they do that. So you get grease on the floor near the deep fryer. And people are walking up to the deep fryer and they slip. And what do you do when you slip? Your hands come out. And what happens when you slip near a deep fryer and your hands come up? They dunk into hot grease. And so we put like 15-year-olds cleaning, operating these deep fryers. And this is an injury that happens a bunch. So, yeah. Yeah.
no, I know. I get it. Like, this is. So then we go into the actual allegations. A recent study by Dateline, for example, assessed the cleanliness of top fast food chains, including McDonald's. According to the NBC News report, more than 120 people were sickened after eating ice cream at their local McDonald's. Oh no, the headlines become more and more alarming.
I mean, I would probably be tempted to, if I was, Lord Emperor of the planet, I would be saying something like, okay, let's change the rules on workplace injuries such that it's not a negligence claim. It's an absolute liability. If somebody's injured at your work, like at your workplace, and you can't show that it is, and you can't show that it was like them being intentional, then it's on you. If your workers are doing dangerous things, then then you as the employer have the obligation to prevent that. Yeah.
Sorry. I mean, to those of you saying it's a ice cream machine, what's the big deal? On September 1st of 2021, the Wall Street Journal reported the FTC, Federal Trade Commission, had launched an investigation into this issue and was contacting McDonald's franchise owners seeking information about the broken ice cream machines. The FTC, Federal Trade Commission, was like, this is a big enough issue that we're actually going to start investigating this.
To be fair, the FTC investigates all sorts of crap. Like if you have a web page where you say this product is on sale and that product is always on sale, they may investigate you. Even if you're not doing huge sales, they will potentially investigate you. So yeah.
Yep. And then there's articles about Taylor's knowledge that the machines were an issue, knowledge of all of that. And then Kitch's product testing reveals that defects were built into the machines.
Yeah. We want this machine to break down more often because then we get to, then we get to charge you to fix it.
So Taylor develops Kitsch innovation relies on data-driven, blah, blah, blah. Before launching Kitsch in 2011, Kitsch founders Jeremy O'Sullivan and Melissa Nelson started a predecessor company, Frobot. Frobot is a fully robotic frozen yogurt dispenser that produces made-to-order frozen confections.
Frobot sounds dumb.
It's kind of fun. It's designed to interact with soft serve machines like Taylor. So basically, it is an add-on. So Taylor has their soft serve machine, and Frobot apparently will integrate additional things into it. Through the venture, Frobot informed Taylor's leadership about its device that promised to augment the capabilities of Taylor machines, including automation and increasing safety offerings. The innovation required years of product development and additional safety testing, given that the process involves serving dietary products to the public. Yeah, that's a risk, man. If you're going to serve a product, dairy products to the public, that's a big undertaking because that's
Really?
a lot of safety.
Really, any sort of product.
Any
Anyone
food.
remember Jack in the Box?
Yeah.
How much money did they lose because of, those issues?
Millions. They almost went out of business.
Yeah. I mean, I was actually kind of surprised to see, to see Jack in the Box is still alive in the US because, yeah.
Well, so Taylor responds positively, and they actually start to work with what was Frobot. They work with them and provide them with a small fleet of machines to start testing and working with. After only a few months of gathering data, it became very clear that Taylor's soft serve machines were not very robust, and the finicky software was causing issues and outages. So they found a new company, Kitsch, to fix those issues. So Kitsch then learned that the C602 machines, the ice cream machines, are designed to prohibit users from accessing the fulsome technician's menu that operates the machines. So they're designed so you can't get to it.
It's designed to prevent you from fixing it yourself. Yeah.
Yeah. The limited menu contains confusing messages that leave McDonald's franchisees frustrated and unable to operate the machine, causing them to call the technician for even minor problems. One example of the cryptic error message is below. Well, that's a fun one. Error like 05.
PC load letter. What the? You tell me you've seen The Office.
Yes.
Not The Office. Office Space. Yeah.
Yeah.
We need the clip here. Imagine, chat, that you are seeing the clip right here.
Yeah, beating the machine to death. So the KSD was developed to allow people to actually read it. So the KSD was like, we're going to bypass this. It's safe. Fine. We're safe. It's all completely harmless.
That beater looks impressive.
Yeah, that was what, I don't know if I say anything after that. NDAs, they refuse to agree. Taylor's early efforts to intercept the Kitsch solution and to access the confidential information. This part was fun. So, protected by binding NDAs with the franchisees, Kitsch released the Kitsch solution in April of 2019 through the confidential Kitsch trial. Around the same time, Taylor's parent company, Middleby, purchased an IoT startup, PhD. So the PhD acquisition by Taylor, quote, increased interest and investment in software and services related to its core equipment business. However, the flawed hardware and software of Taylor's machines blocked PhD's attempts to develop a workable IoT solution. So instead of developing its own products, Taylor started trying to obtain KSD less than 3 weeks after Middleby bought PhD. 3 weeks. They bought the company 3 weeks, and now they're trying to get that. The attempts to secure the information failed because security protocols flagged an attempted espionage. During routine monitoring of its website in April 2019, Kitsch discovered that Taylor representatives were trawling Kitsch's homepage, including its terms of service. This and other communications notified Taylor that Kitsch's operations, including its proprietary information and computers, were based in Fremont, California. After scraping information from Kitsch's website, Taylor attempted to purchase a KSD. On April 23rd of 2019, Taylor VP of Quality and Consumer Service, Dan Domberg, instructed Taylor Service Technology Manager, Heather Jordan, to order a KSD through Kitch.com. Kitch flagged and then canceled Miss Jordan's order after matching her shipping address to Taylor's headquarters. Nah, we don't go give you our proprietary shit. That's what
You know what I would have done as well? I would have canceled the order, and then I would have taken a box and like filled it full of something. Something funny, not like poop or anything like that. Nothing where they could sue you, but just something like, like stickers, like marketing stickers or something like that. You just cancel their order and like you send them some swag.
Now,
a T-shirt with your brand on it.
So I see the other side of this. You're allowed to order other companies' products and reverse engineer them. There's nothing that prevents that. So I don't think this is as nefarious as what we will read in a minute, but I don't see a problem with them trying to order it. Like,
yeah,
hey,
and there's no problem with you saying we're not going to do business with you. And
yes, we should have ordered in stealth mode. That's what was said back and forth. I guess we should have ordered in stealth mode.
The other fun thing, though, is that you could have so much fun with it. I'm sure there's got to be like, because there's various companies that'll do like custom printing. I'm sure there's got to be one that will do like custom printed condoms, and you could send them like a whole, like 1,000 Kitch branded condoms just for a joke. Because that's how you tell your rival to go F themselves.
You could have found anything else. It could have been poop. It could have been anything else. And you were like, no, we're going to label condoms. That was where your brain went. I just want to highlight that. That was where your brain went.
Well, yes, because the message is
prophylactic, preventative care and maintenance. Taylor doubled down on its efforts, and its counsel hired at least 2 private investigators using assumed names to try and avoid raising suspicion. Just like the previous orders, Kitch's security precautions flagged and thwarted these attempts from Taylor to obtain KSD.
So there is actually a company that does this.
There is.
I feel like the universe should not trust me with this knowledge.
So after all of this, Taylor then says, we're going to do a cease and desist. So after spending the previous 6 months trying to secretly obtain the KSD, attorneys for Taylor emailed and called Kitch to discuss potential licensing arrangement. Oh, now that's the thing. Kitch is probably like, F you, man. Because now you have tried to steal my shit. You have tried to buy it and reverse engineer it. I have caught you both times. And now you're like, hey, licensing arrangement? Like, oh, boo-boo. You could have done that at the beginning and not made me so pissed. The discussions ended after Kitch informed Taylor they would not share any proprietary information. As well, I agree, unless Taylor signed an NDA. You're damn right. I'm not going to give you the inside workings of my machine unless you say a non-disclosure. Oh. According to Minard, by the end of 2019, less than 4 months after Middleby acquired PhD, the company they had acquired for this purpose, Taylor decided to stop further development on its own IoT platform because Taylor lacked the resources and expertise necessary to devote to development of an IoT technology. Are you guys reading between the lines? 4 months later, after they hired a company with the express purpose of developing this, and in those months, that company did what? They tried to order the product, nefariously order the product, obtain the product, and then tried to license the product. And when they failed, they were like, we can't do it. Yeah. Oh, I see Ari in the chat. Has anyone ever seen Silicon Valley Show? Remember the Brian R. Word episode? This is literally it. I don't know that one. Good to see you, Ari. Hope you're doing well.
Ari, I'm going to try to do the thing for
the Taylor thing.
For Monday, I want to cover it.
Good. I haven't read it yet. So I'll be glad.
It's fun.
Is it really? I hope it is. Was there a lot of SmackDown? There should have been SmackDown.
It's fun.
Okay. So Kitsch expands and they start integrating into the different franchises, and people are like, oh, we can fix it. This is great. Look at this. These articles. In February 2020, news outlets reported on Kitsch's success. McDonald's and Burger King franchisees are raving about a new device that can update their notoriously broken soft serve machines. Oh my gosh, lick of time. McDonald's ice cream machines may never break down on you again thanks to a new device. New device may prevent McDonald's ice cream machines from breaking. A new device promises to keep McFlurry machines up and running. That's a lot of articles. That's good headlines. Good press.
And the thing is you would think McDonald's would be thrilled that now their products are up and running, and
No, because they tried the subversive approach first. Here's the thing. If there's a competitor in the market, not legal advice, just practical advice, maybe approach them and say, hey, I like the product you have there. How much did you spend to develop it? Would you be interested in selling it? No. Would you be interested in licensing it? An NDA? Yeah. Sure. What terms? That's where you begin. You don't go and surreptitiously try to reverse engineer, hack it, and try to scrape information off their website and then go, oh, sorry, we screwed that part up. Now do you want a license agreement? You don't do that part.
Or you recognize that if you do, they're going to charge you asshole tax.
Yeah. And I think that's what Kitsch probably came back with. Like, hey, here's the asshole tax. And McDonald's was like, no, we're not doing it. So instead, they just want to take it down. It is this is I will have reminder. This is all over ice cream machines.
Oh, I mean, there's
ice cream machines.
It's really over money.
So, McDonald's director of global equipment emailed Tyler Gamble and Eric Wilson right after meeting to thank them for agreeing to test Taylor's competing product. McDonald's also stated that it would arrange options with Gamble on how we should approach getting the device. Tyler Gamble acted quickly on the morning of February 14th, Valentine's Day? That's fucked up. Less than 1 day after the February 13th meeting, Gamble's emailed the Kitsch founders to enroll in the Kitsch trial. Gamble spoke with Kitsch later that day at McDonald's and Taylor's urging. Gamble told Kitsch's founder that he was eager to obtain the solution. He also offered to serve as a liaison between Kitsch and the fast food giant, promising to solidify Kitsch's relationship with McDonald's. Unbeknownst to Kitsch, after Tyler Gamble contacted Kitsch, but before he signed the Kitsch trial agreement, the CEO of Taylor, James Menard, asked McDonald's leadership to, quote, please let me know when you and your team have secured access to a Kitsch unit, and I will have my team available for a complete review. This is fucking This is wild. This is corporate espionage. This is insane. You're hiring like these third parties to go in under the guise of a different entity to obtain a device, and you are surreptitiously emailing back and forth between the heads of the company saying, let me know when you have the device, I'll test it.
You know what this sounds like?
What?
Sounds like some pigeon business.
This is some pigeon business. Insert shameless plug. Were you making that? You did not. That is a fucking condom. Ian Runkle.
There's a company that allows for this.
I regret having you as a friend. No, I don't. I take that back. Sometimes I regret having you as a friend. You son of a bitch. Oh my God. Ian. Sorry. It's a fucking condom. While you've pulled that up on a prophylactic, why don't you explain what prison business or pigeon business is?
So I was talking about Jeanette M. Braun, and I was basically saying that at a certain point, it gets hard to tell whether somebody's tactics are like because they have a plan, or if it's just pigeon business, as in like a pigeon on a chessboard knocking over pieces and crapping everywhere. And so people were like, I need pigeon business merch. So I made shirts. But
that is not the merch. That is not the merch. Because I can guarantee, as a family lawyer,
oh, as a family lawyer, probably drum up business for you.
No, as a guarantee, you do not want to be selling a prophylactic.
Oh, I do not know.
One of the emails coming back to you, or one of the claims coming back to you, is that it failed to work, and now you owe child support.
Oh, I'm not selling these. That's not happening. But it's still funny as hell.
Oh my god. How? I know when your eyes are off screen for long enough. I know it. When your eyes are off screen for long enough, I damn well know that you're up to some shit. Or
and I had to like adjust that picture to get it to be the right size.
Oh, you son of a bitch. Okay. Oh. Okay, that was pretty good. That was pretty good. Now focus back on the lawsuit that I was covering. On March 12th, 2020, approximately 1 month after he first emailed Kitch, Gamble called Kitch's founder, O'Sullivan. During the call, Gamble said he would leverage his position with McDonald's equipment team to encourage McDonald's to adopt Kitch's technology. He also said McDonald's and Taylor were offended that Kitch did not approach them directly and that Taylor would manufacture safety concerns to make Kitch's go away and leave the marketplace. At the same time, Taylor and PhD continued to struggle to develop. They were struggling. They couldn't figure it out. They tasked the tech manager to develop the interface. That failed, yada, yada. Then this led to PhD couldn't identify when the machines experienced errors, when buttons were pressed, or when functions were engaged to display on the user. So PhD, they can't even figure out their own damn machine. Quote, I think we need to have a heart-to-heart conversation with PhD. I'm concerned they don't have the resources to support us. I sent them user interface feedback a week ago and have not been able to confirm when the changes will be made. I know they're probably in the same situation we are, but we need to understand their capacities before we can make a decision to move forward with them. So literally this competitor that they purchased is not holding up. And Kitch is like, we got our thing. And this competitor's like, we can't do it. Mm-hmm. Gamble shares Kitch's confidential information with McDonald's, TFG, and Taylor. So on March 19th, Kitch and Gamble enter into a binding contract where in exchange for Gamble's covenants of non-disclosure and secrecy, oh, this is the corporate espionage, Kitch agreed to provide its confidential information, including the Kitch solution device, to Gamble to use for the sole purpose of furthering the Kitch trial. When he signed the agreement, he agreed he would not nor permit others to access or use the solution in order to build or support and or assist a third party in building or supporting products or services competitive to any Kitch solution. Now, for those of you asking, why not sue Gamble? Gamble doesn't have money. McDonald's does.
I mean, you sue Gamble too, probably, but
you do, but that's easy. That's too easy, and it's not nearly enough money to compensate for what you would have lost. So Gamble shared the information with McDonald's. Specifically, he provided the device to the company and even gave TFG his login credentials. So it's like, here's not just the device, but my login credentials, which they said, I will give you under penalty of you shall not live.
You shall not live.
Then he forwarded notifications. So he does even further. He gets notifications on his side and forwards them to the other side.
No.
What a skeezy thing. This is nasty. On June 3rd, Blaine Martin asked the Gamble if TFG could access the KSB to see the data it provides. Oh, my God. This is gnarly. then they share the information with McDonald's throughout 2020. So throughout this entire year, this information is passing back and forth. So of course, McDonald's is developing their own version of how to do this. McDonald's and Taylor tried to ramp up product development and after receiving feedback from Gamble, but instead of coming up with their own innovations, Taylor's COO, James Menard, emailed Taylor engineer Joseph Beard to ask him, quote, so how can we do the same thing Kitch is doing as far as sending commands from a remote interface? How do we program our thing like they did? Wow.
We suck. How do we not suck so hard?
So then Kitch gets endorsements from all these other people. Public backlash against McDonald's for doing shady shit. This lawsuit is massive.
Wow. Wow.
Yeah. So that's where things are. I never thought I would like the food court thing. What are we asking for? Let's see what we're asking for. Nope, that's non-disclosure. That's that count. Counts. What were count third cause? Let's get the first one. That's where the money's going to be. Where are we? Destruction of business. First cause. Kitch entered into NDAs to trial participants, blah, blah, blah. Incorporated the agreement. Breaches. Economic harm. Where's the money? It's at the end. Give me the money. Give me the money. Show me the money. So we are asking for injunctive relief. Stop using our shit. Stop messing with our shit. Leave us alone. Surrender our stuff back. Stop saying, keep our name out your mouth. Awarding Kitch compensatory damage in an amount to be determined at trial. Lost profits, expenses, exemplary and punitives, interest, all the above. Give me all the millions. So that was filed March 1st of 2022. And now we are here because it's been transferred back and forth. And Rutro, one of the lawyers asked to withdraw. So I think Kitch might have run out of money to continue the suit.
Oh, that's sad.
I don't know. It is. But that's the story of like what happens. And that's the thing. Like I think McDonald's, they know going into this, they know that these other companies.
Oh, you can run people out of money if you're McDonald's.
Easily.
That said, I'm surprised they don't have somebody who's willing to do this for a chunk of the money. Like a lawyer who's doing this on a contingency. Well,
that lawyer knows they have to, like, you remember we talked about the Take Care of My trial, right? And Greg Anderson, how much he had to put up. Like,
yep.
You need a lawyer who has that level of resource, who's willing to put up millions in advance to try and get this to trial, because you know that every fucking hurdle is going to be put in the way. Every hurdle. Procedural, jurisdictional, all of the above.
Oh, yeah.
I don't know. Oh, yeah, I saw that. Kitch's attorney filed a lien for attorney's fees against the case. Yeah. Because they had to withdraw because they weren't being paid. That's what sucks. That's what happens in cases like this, where you go against a company like McDonald's and the lawyers can't keep doing it. They run out of money. So let's see. McDonald's content and questions. was I? Mispronounced name. If someone prints an AI image, takes a photo of the printout and publishes the photo, would they have a copyright? If yes, would a screenshot work? That my brain hurts. That's a lot.
You'd have a copyright over the photo to a very limited degree. The problem is that you wouldn't create a copyright over the actual AI image. So if somebody replicated the AI image, you wouldn't have anything at all. What
Yep.
you would have is a copyright over the creative elements of your photography of it. And if your photography of it added nothing to that base image, then there would be no so yes and no.
That's the Warhol debate, where did simply inversing the colors on the print add anything? Like, did it change it to make it something new?
Yeah, I mean, photographing other people's work or other images, but you're not going to create a base copyright to the AI image.
Yeah.
If you have an AI image that you think is fantastic and you want to get a copyright over that, then what you need to do is do substantial revision and editing and so forth, where those changes can themselves be something that is copyrightable. So yeah.
Yep. Saskia, ice machines never broke in the Netherlands because you have ice all the time. Billy's Momzilla, did the contract
The
prohibit
Netherlands
using...
isn't that cold. Come on.
It's not that cold. I'm just teasing. Did the contract prohibit using diagnostic tools or just service calls? It said it voided the warranty, which is just a big threat. Nance70, I do so enjoy these lives. I do too. Poison Elf, want to bet Taylor's techs extort repairs and how quickly it gets done. That's some of the allegations. It's just, can you prove it? And how long does it take you to get to trial? Angie, Robin Runkle, did any of y'all ever hear about one of the defense lawyers in the YSL RICO getting arrested on gang charges? I did not. I'll check that out.
I've heard about it, but I haven't heard any of the details yet. I haven't gone into that. So,
Chris Cat Queen, McDonald's, based on chat, the broken machines appear to be a US thing. Canada, Japan, Kuwait, South Korea, Europe has no such issue. I wonder if that's because Taylor, I wonder if it's the same manufacturer for the machines abroad. Nancy D, McDonald's people getting sickly from their iced tea as they don't clean them the right way. Asked to put plastic bags in first to keep bacteria from getting. Oh my gosh. Yeah, iced tea, especially sweet tea, that sugar, will accelerate any growth in that. Yep. You got to clean that way, clean it. The world wonders. What I hear is Pigeon Business Brand. Oh, condoms. Shelby Fortney. Hey, Rob, Hub's got a job at Fort Belvoir, so our fam needs to move. Are there any areas you'd recommend over others when looking to buy a house nearby? Shelby, I will tell you, there are 3 people I know that are moving to the area. If you send me an email, I will try to help get you in touch with a real estate agent that I know and trust in the area, and I'll give you some advice on neighborhoods. Allegiant News, condoms as merch for family law practice? Nope. I'm not taking that liability on at all. AG, just spent 8 hours transcribing the most dramatic and spiteful depo I've ever done. Those attorneys hate each other. I have a headache. Hope y'all are having a better night. I love my job.
So something I thought about doing, and then I contacted the Law Society, and the Law Society said, don't do it. I actually know that there was a lawyer, but they don't do, they do traffic law, and they put out some branded condoms as a marketing thing. And they basically said something along the lines of like, avoid accidents.
Mm-hmm.
Law Society told them to knock that off.
Mm-hmm.
What do you call it? But the one I wanted to do was like coasters. that had like my number and something that said something like, I guarantee I'm more expensive than a taxi. Take a cab home.
We get those. Like we have those.
The US allows for a lot more advertising than Canada does. Like where I am, lawyers, we are basically allowed to advertise like we exist and here's our law firm name. We can't advertise anything that suggests that we are a better law firm than other lawyers. We can't advertise anything that suggests any sort of like demeanor or style. So you can't suggest aggressiveness. You can't suggest any of that. I have literally seen that. A lawyer I used to work for by the name of Sean Beaver wanted to do advertising for like radio advertising. And so they made a whole bunch of different ad like scripts for the host to read, and they ran them by the Law Society. And the only one the Law Society apparently agreed was okay was basically, if you have criminal charges, call Beaver Law and then the phone number. And the radio company didn't want to take it because they thought it was a joke. And that the dog in the background is my alarm for I have food. I'll be right back.
Okay, you go do that. Judy got this. Kiddo gets a new pup next week. Play dates with Leo. Fair game. I'll do that. Melanie Paré, what is Mischief's favorite color? Asking for a friend. Orange. Orange is her favorite color. Rabbit, love the pups. We all love the pups. Nurse Jojo, Fani said that she used Cash App. It's a mobile app. She would have the record of any payments she made using the app. She said that with friends and other people, not with Wade. Ronnie McMahon's, thank you. And definitely watch your capitalization and spacing when writing physiotherapist. There. Melanie Paré, thanks for becoming a member. Nurse Jojo, thanks for becoming a member. Camilla, thanks for gifting memberships. Much appreciated. Donna Parker, thanks for becoming a member. Fiona, gifting more memberships. Canonical Heat, gifted memberships. Thank you for the overwhelming support. Debbie Seltman, lawyer, puppy lawyer. Yeah. Ian showed up right when you said it. 3 inches freedom units. 7.62 centimeters up here in the Great White North. Now you know why we use metric. LOL. Michelle Maynard. Doggies need button that says call my lawyer. Oh, that's a good one. I need to save that. The doggy needs a button that says call my lawyer. Yeah. Stephanie Miller, thank you for the super chat. I had stopped woodworking for the last 8 years after I'd lost all my tools. Thank you for encouraging me to get back into it. Loving making sawdust again.
What you need to do then with the call my lawyer button is you need to train the dog to do a trick, which is you tell the dog speak and the dog runs over and pushes the call my lawyer button.
Cute puppy. I'm going to say that was for Zora and Leo, same ones. Patricia says,
you see Zora kicking in the background?
I did. Yeah.
That's because I have food.
Yeah. Nancy D, Rob, check out the Crazy Trial RA show today. I will try to do that. I usually watch a little bit before I go to bed after these streams because I'm a little wired. Aqua saying, hope Mr. Runkle is feeling better. We have echoed that sentiment.
Yeah, working on it.
K-Rab, what brand are the buttons for the dog? I just sat because my grandma to a chocolate lab. My daughter needs those buttons. I don't know. They were a Facebook marketplace like giveaway thing. So I guess look on Amazon. Dirk Schwartz. I think Hannah's legal surname is Gutierrez and not Gutierrez. My stepdad is a famous, contrary to me, competent armor.
Correct.
Ian, you have some comments on this. This
Yep.
was a weird thing. So can you explain what this is?
So there was some shade in the issues there because so Zora is here to investigate my my dinner. So the shade was basically that Hannah's lawyers have been saying Hannah Gutierrez-Reed, and the prosecution is like, no, every court document should reflect that it's just Hannah Gutierrez because that's her legal name. And the only reason she wants to go as Hannah Gutierrez-Reed is for an association with her much more famous father, but her name is actually Hannah Gutierrez. And so, yeah. So that is, I mean, it's a little shady that they're like, you gotta use your actual, but I mean, at the same time, it's correct, right? That is the name that it should be under. So, I don't know. I haven't decided yet what I think of that one, but I think that they're correct in insisting.
I think they're right. I think they're entirely right, because here's the thing. You are the state prosecuting a person. That person is that's who they are. It's their name. Right? You have an official name that you have. That is the name that the state, the government knows you as. It's like Darryl Brooks. No, you are not this magical person that you pretend to be. You are this person. So even though you're going to say, I am not this person, you're still the person. So I don't have a problem with it. But I did find it funny in the hearing and listening to the hearing, even though, I mean, they both attorneys still stick to their guns on this.
Oh yeah.
That was a bad pun, but they both stick to their guns on it. Terry McLean, careful what you wish for. I taught my pupper to ring some bells to go outside to go potty. Problem is now he knows to ring the bells if he's bored and wants to go outside and stare at nothing. That's a Zora move. Lexi, I understand the partner started firing as well, and both equals still a cop.
I think the one guy resigned. The first guy.
Fiona, thank you for gifting memberships. Fat Yoga, thank you for gifting memberships. Tommy Jones, hi, Rob and Ian. Love it here. Thank you both. We love you too. Thank you. Knight, where has this year gone? It's already the middle of February. I don't like it at all. Sandy, please don't forget to hit like and subscribe. Please don't do that. Sandy is one of my wonderful mods whom I've had the opportunity to hang out with in person, who is just as wonderful in person as she is in the chat. Finally, Freed, thank you for the super chat. Pants, shout out New Hampshire Judge Messer, top notch new favorite. Ooh, I have to check that out. Is that the Reed trial? Where's that trial? Because isn't that coming up? They declined to continue it. I know that.
Not sure. I really like the New Mexico judge.
Oh, I love her. She's fantastic.
Yeah, she was just
she is like.
I just love how they're making submissions, and she's like, "Isn't that bullshit, though?" She doesn't quite say it like that, but it's like, you sure?
Yeah, she's pretty awesome. Holly, thank you for the gifted memberships. Mary Jane, really not Sarah. Ian, I'm worried about you because your door is open. Well, Zora was going to find her way in anyways because Mrs. Runkle is incommunicado.
Mrs. Runkle is away, so I don't need to worry about accidentally capturing her on video here. But it's just letting Zora come in. But now she's really curious because I've got food.
Yeah,
that's what's
Janine.
That's what's making
Job
her happy.
79. Thanks for the gifted membership. Zora is I love Zora. She's a wonderful pup. I need to meet her someday. Mindy, not when it's freezing cold in Canada. I will get up there this summer when it's not freezing cold in Canada. Mindy FS, I'm an original gangster on this channel. Mindy FS, member 14 months. OG indeed. And then Bambarina comes in with 18 months. Can't believe I missed the GS Girl Scout cookies. Glad to spend Friday with you and Ian. Y'all are amazing. Shall see. Thank you for gifting memberships. Stephanie1208, thank you for gifting memberships. KPT, Heart FNFs, and with my two favorite YouTubers and the shirts, guys. Yeah. Torin 3, I've got Constable Con Ed tomorrow. 8 hours of reviewing Graham and Gardner. Oh my God. And they want us to do more court security for $13 an hour. Ouch. That's
nothing like getting stabbed for $13 an hour.
That is bullshit. I'm sorry. Torin, I'm sorry. Find some happiness in the shop, my friend. Find some
I'll s-
happiness and peace in the shop.
Also, Zora right now is sitting here going, she's giving me a look because she's like, why are you not sharing more? I only got some small pieces. What?
You are
Why?
inferring, you are speculating that is inferring intent upon my client. I would ask that you stop doing it.
Are you saying that that isn't what this expression is? That she isn't seeking more food?
I will fight back as hard as you fight back against every comment I make about Leo. Every time.
All right. Well, then
This-
you've just talked your client out of some more snacks. I don't think your client's going to be happy with you. I think she may terminate representation.
She's not. It's not about keeping her happy. It's keeping her out of legal jeopardy. That's the point. That's the point. Side note, that's one of my favorite things about the internet these days is that dynamic. Like anytime there is as Emily calls them, the paw nerds, anytime one of the pets gets into some mischief, the number of tags that I get on YouTube or on YouTube and Twitter. And then when I make a comment about Leo, the number of tags that you and Emily get in response to that, that has made my existence so happy. It has been so much fun, that back and forth. So, yeah.
And people are saying, where's Potter? Potter is almost certainly sleeping downstairs.
Oh, yeah. Potter's like, I'm done with this bullshit. Zora is awake and I just want to sleep. Lindsay, so how do we get a button for Leo that says, I want my lawyer for when he wants attention and is being ignored? Since that's clearly legal. I don't know. The internet will, I don't know. Allegiant News. Can you advertise you suck and we'll lose the case? I don't know. That's interesting. Like, can you advertise I am a terrible attorney and I will lose your case? I don't think so, because you have an obligation to zealous advocacy.
Yeah, I think that would actually probably run into some issues with like undermining the public confidence in the administration of justice.
Yeah.
Zora, I can't give you this because this is full of garlic and garlic is not good for pups. She's like, I want to find out.
Well, she likes Tabasco. Baby steps. Thanks for the gifted memberships. Lisa R. Color for call my lawyer button. I'll make one. Purple. Purple / blue, like a deep blue purple, like a mix between the two, because Leo has two lawyers, one for when he's just in shenanigans and one when he's in deep shit, and he's both of them. Elise, I lost my kitty Zora on Sunday. I'm sorry, Elise.
Sorry.
That's really hard news. Those are that I've had those losses and they suck. Vicky Regulo, thank you. Ari. Oh, I knew this was coming. I forgot to give you guys shit for coming to my city, Vegas, and not grabbing a drink with me. Next time,
I didn't know you were
heads up.
I didn't know you were in Vegas.
I knew better. I was flying in on like a last minute booked flight. And
his last minute was like, I don't know if I have a flight. I'm gonna be there. It's gonna be like a stupid time. So
it was, but I'm sorry, Ari. I should have given you a heads up. Next time I'm in Vegas, I will. Actually, we'll probably be. I think there's a trip coming up. I don't know. But the same goes back to you. If you're ever in DC, you need to let me know.
If you're ever in Edmonton, which you won't be.
Rosebud 26. Can't believe it's almost a year now. Been great. Thank you, Rosebud. Bop it. This pup is hanging out to support the paw nerds. Awesome. Ian Paler, my uncle lost his lap buddy. Oh, no, not easy.
Oh, that's
work from home lap buddy. Yeah, no, the loss of the pets that's really hard. That's really, really tough. Okay, let's swoop. And then I want to do a very quick sports ball thing while you're eating your food. One more. Okay, so two things I didn't think that would ever intersect in my life, and that is TaylorMade sues Costco. TaylorMade has sued Costco. Yes, Costco, the big box store that it's like we will sell everything in bulk, and they sued them over patent infringement on sold out Kirkland signature irons. So golf clubs are really damn expensive, and there's a lot of technology and development that goes into them.
Sell your golf clubs, buy a rifle.
Millions of dollars. So Costco has its Kirkland signature brand, and TaylorMade is, well, a multi-billion-dollar company. When Costco raised the profile of its interest in the golf business by introducing a line of irons last year under Kirkland's signature name with hollow construction and multiple materials, its price point and design claims drew immediate interest, much like its golf balls in recent years. So, for those of you who don't know, golf balls are expensive. For a box of golf balls that are, what is it? There's 4 to a sleeve, 4 in a box, 12. Yeah. No, 3 to sleeve, 4 to box, 12. A box of golf balls, 12, will cost anywhere from $35 to $50. So Costco was like, oh, it's better. So they borrowed the company resources and manufactured golf balls that were ostensibly about as good as the highest price point. Well, they did this with golf clubs too. So the irons quickly sold out in a few weeks. The general consensus seemed to be that the $500 price point, the new irons, either were going to dramatically shake up the golf business or end up being too good to be true. So, for reference, you're talking about $2,000 versus $500. So Costco is in the cost. Now, one golf manufacturer is suggesting the latter in court. TaylorMade, one of the biggest and most innovative companies, filed a lawsuit Wednesday against Costco, a wholesale retail giant whose 2023 revenue was nearly $246 billion, or approximately 150 times what TaylorMade sold for back in 2021. The complaint suggests that the new Kirkland signature irons not only violate 5 TaylorMade patents surrounding its irons, but that Costco also falsely advertised how those irons actually are constructed. The Kirkland signature irons retail for $4.99, but currently are listed as sold out. TaylorMade's versions sell for $1,400. I was close, not $2,000, $1,400. So 3 times the price. Filed Wednesday in California because, of course, why not? The 237 pages of complaint and exhibits from TaylorMade detail patents on iron designs that go back a decade. The primary issue centers on the Kirkland signature player's iron, an iron that was introduced in late 2023. The lawsuit
I'm just going to say, normally, if you spend this much on your balls, it ends up being my kind of law, criminal defense.
Or my kind of law, family law.
Yeah, that too. I mean, it can be both. There's a lot of files that are both.
Yeah, that's true. So the lawsuit names Costco and the design partner for the iron, Southern California Design Corporation, for violating TaylorMade patents involving many elements of the hollow iron design, including an iron with a dampening filler material, blah, 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 stuff that you guys don't care about. According to the complaint, the design of the accused products directly copies the patented features of the P790 irons, including features covered by the asserted patents. On information and belief, the design team for the accused products included an engineer who formerly worked at TaylorMade headquarters. Oh, so they literally hired away one of the engineers.
Yeah, that's a bad fact. That's what we call a real bad fact.
Yeah, that's a really bad one. So you hired away one of their engineers, and all of a sudden the product you make looks exactly like the old one. Yeah. Yep. Mm-hmm. While the design of TaylorMade's irons differs from those of Costco, the defense of the patents that still very much relate to the fundamental design of the current iron is paramount for the company. Quote, our irons not only revolutionized the filled iron category, but also invented a new category in players' distance irons. Look, these guys are just arguing about their shit. They quickly became iconic in the marketplace due to their superior technology and performance for all golfers, as well as their overall sales success. So, little known secret about the golf world. When you suck at golf, there are two options that are available to you. One, you practice a lot. Two,
You complain about your gear.
and you buy new equipment.
So how much golf equipment do you own, Rob?
Not that much. I actually practice. And when I don't blame my bad game on my equipment. I blame it on my practice. So I blame my bad game on the fact that I don't get out the course. But two, you blame the equipment to buy more stuff. That happens to be a very lucrative marketplace. My God, the amount of money people spend on equipment to try and correct a slice or this thing on a game that's supposed to be relaxing. This game is supposed to be relaxing and a challenge to you mentally. I love it. I know that you have an opinion on golf courses that is in line with every golf course is a shooting range that should have existed. We have had that
Correct.
conversation. I find therapy in golf. I enjoy it. It is a mental challenge to me, and it is a way for me to get out and enjoy a good walk, a good stroll, and do those things. I love it. But you'll never find me buying a new $1,000 driver because with my
Because
shitty
you
swing,
broke
it
the
ends
other
up
one?
going. No, with my shitty swing, it ends up going into the woods. No, that's my shitty swing. But there is a massive market of people who are like, I don't want to fix my shitty swing. I just want to hit the ball straight. So, yeah. This is really funny. I have a video of this. Kelly P. Rob, do you take after Happy Gilmore?
Happy Gilmore is one of the very few good sports movies.
Mm-hmm. So my brother and I had a tradition. We're on the 18th tee. We would hit 2 golf balls. We would hit our regular drive, and then we would allow each other to hit a Happy Gilmore shot. And the rule was, if your Happy Gilmore shot ended up in play, you could play that. So
how often did that happen?
One time. I caught it on video. And it is hilarious watching the swing at that golf ball. It was probably 10 years ago. I have to dig that video up and find it. I'll show that during a members only. That's a members only thing. That's not a on this stream thing. So when another company seeks to imitate our products, we take it very seriously and take immediate action. Not only are we protecting our intellectual property, but we are also seeking to protect golfers who may be duped
No, you're not.
and misled into thinking cheaper imitations will perform at the same level as the original.
We want to protect
God.
golfers from low prices.
That's a terrible take. TaylorMade, fix your shit.
I mean,
What
the
a
thing is
terrible
if you
idea.
want to argue that you're going to protect golfers, what you need to say is these products suck. But it's hard to ride the pony of these products suck and these products are stealing our technology. So don't tell us that, you're out to protect golfers, because really you're just out to protect golfers from saving money. Yeah.
Yeah. Neither Costco nor Indie Golf responded to requests for comment. No, nor would they, nor should they. Their lawyers told them shut the F up. According to the Costco website, the Kirkland Signature Players Iron, that's a long ass name, man. Costco, sure, fix that shit. Featured a hollow
That's
design.
how Costco rolls. They don't care
I
about
know,
the names. They
but
don't care about the packaging.
But so TaylorMade, I will say this: you want to compare brands. TaylorMade has the P790s, right? Really easy. Then every time you have
How's
to say
that easy? That's like a combination.
Let me tell you how it's easy. Compare it to this: Kirkland Signature Players Iron.
At least I know what one of them is. I'm
Sure.
sorry. I think I prefer the Kirkland name.
Fine. But it features a hollow design, tungsten weighted, and injected urethane insert within the body. TaylorMade's P79 irons were first introduced in 2017 and were unique for their hollow design, featuring tungsten weighted and polyurethane foam interior. There's the manufacturer, there's the polyurethane interior, the all the above. That's the Costco website that features those irons. As detailed in the lawsuit, the Kirkland signature irons already had drawn comparisons to past generations of the 790s on social media and elsewhere. Even the company's website graphic of the iron's design is similar to the graphic TaylorMade used for the second generation P790. This is also why you don't hire the same engineer.
Yeah, because the graphic is, of course, going to look similar because that's, yeah.
That's not just similar. It's like hang on. Oh, no, it doesn't have the bottom thing, but that's like pretty identical. However, the lawsuit contends that Kirkland do not contain any injected urethane insert, leading to the complaint for false advertising. The statement made by defendants in the accused products contain an injected urethane insert is literally false. Oh my gosh, when you throw literally into a lawsuit, my God, I need that. I need a lawsuit where I can throw literally into a lawsuit all the time.
I generally recommend that literally should not be used.
Well, and here's where they lose credibility because it's literally false, or in the alternative is misleading. And no, if you're going to say literally, say literally. Depends false.
I also hate how literally can mean literally, but it can also mean figuratively.
I know it's terrible. People.
Zora also hates this. She's a good dog.
She very much does. Defendant's false. Oh, someone asked a question. How different can golf clubs look? Very different. Very. Defendant's false advertising has misled golf journalists and customers to believe the accused products are similar to or equivalent to the 790s. Blah, blah, blah. Point generally, yada, yada. All right, we're in federal court. So PXG has sued PXG, and this was my thing that I learned, was it wasn't just Costco, but apparently this happens a bunch. It's not the first time that P790 irons have been subject to litigation. PXG sued TaylorMade in 2017, claiming infringement on its iron designs, and TaylorMade subsequently countersued. That disagreement was settled out of court in 2019. Yeah, because that's a lot of money and a lot of IP that you're throwing out in the world, with both sides issuing statements and agreeing to specified rights to make club products under patent cross licenses. Yeah, because it's a lot of money and a lot of IP that becomes public knowledge. It's also not the first time Costco has been involved in legal action with major golf companies. Costco and Astronet, parent company of the Titleist brand, sued each other in 2017 over golf ball patents. So Costco is just making the shit that we love cheaper. And I appreciate that, and I like that, and that's wonderful. But they get sued for it sometimes. So that was just one little story I saw that made me chuckle a little bit. Lost in a crowd of 3. Do you have the Orville Moody putter? No, I do not. Elizabeth Me, Rob, thank you for creating an amazing community. Thank you for being part of that amazing community. Katrina Turner, I just want my local golf course to let me use both sets of clubs. I can't choose left or right-handed clubs only. Really? That's confusing. I wonder if you're trolling me or not. I don't know. Huh. But you can. What's wrong with that? Interesting. Susan Feria, thank you for the super chat. SGC, according to them, the Miss Brazil lefty did great. Didn't like not having enough time to target my target. It was great getting the knowledge and how abroad it actually is. Thank you. I'm glad. Thanks for, I haven't seen you in a while, Susan. Glad you're doing well. I still have all of your stuff around. All the crocheted best blue balls. Tickle pickle. They're still here hanging out. Thank you. Billy's Momzilla. Yes, a box of 12. I know my math was not mathing at the moment. Blessed in Texas. Rob, I sent you a private message on IG last Friday. I don't get to check DMs, and especially with freaking court. Like I didn't even check anything. I've sent you messages like I can't function.
I've sent Rob a
Most
message on, whatever. And then he sends me back a message like 6 days later. Like, he's just read it. And it's, and he's like, hey, and I'm like, all right, that's what we were talking about. Rob has been super busy.
And I don't like it. And it's disrespectful and I need to fix it, but it's really
just law.
frustrating. It's law and it's very frustrating. So I will take a look, Blessed in Texas. I'll try to get to, if this snow comes in, I'll have time this weekend. Allegiant News can't say, Canada can't say are good or just or bad, just mediocre. I don't know what that means.
Canadian lawyers. I don't think you can even say you're mediocre. You just can't really speak to that.
You're just a lawyer.
Yeah. There is one that was funny. I sent it to you a while ago.
Is this the Hawk?
No, this was the unicorn lawyer.
Oh, I like the Hawk one. He was good too.
The Hawk one is not Canadian. So I'm just trying to find. I'm pulling up their webpage. Do they actually have unicorn stuff on their page? Doesn't look like it. Sorry, guys, you're missing out. If you had the unicorn stuff on your page, I would totally pull that up on the stream here. But oh, wait, here we go. Here we go. So nope. So unicorn of injury law. That is their advertising.
Wow. Okay.
I was saying this is the firm Rob needs to work for.
All right. I like my firm though. I get good support.
You don't want to do personal injury in Canada?
I don't. I really don't. I am being honest. I don't.
I don't want to
like
do
what I
personal injury in anywhere.
I don't either. I don't like it. Kathy Trout, I'm ashamed of you, Ian. When I go out / order in to eat, I always get my fur babies their own meal.
Zora gets a little bit, but
she likes Ethernet cables.
She likes Ethernet cables.
Allegedly.
They will get treats as well. But, I mean, a lot of Chinese food involves garlic. And not good for dogs. So, yeah.
Okay, so Blessed in Texas, I'm going to ask you to email me, please. lawandlumber@gmail.com. The DMs get those, they get lost because Instagram categorizes them in like different categories, but emails I can read. Hey guys, hi Rob. My two broken hands have healed. Remember you were impressed I could still type. Absolutely.
Yeah.
LOL, only broke each fifth metatarsal. That's not inconsequential.
That still sucks.
Yes, that's miserable. Yes, I'm impressed you can type. I'm impressed you're here hanging out. Thank you for being a part of this chat and a part of everything. Yes, amazing. Jane Michael RM, thank you for getting memberships. Remarkably gracious. Billy's Momzilla, I lost all but one gifted golf ball at attorney. I won a prize.
You won a prize for losing the most golf balls?
Well, I mean, I don't know. Mispronounced name. I'm currently.
I feel like golf courses have some of the most expensive pond sediment that you could possibly get.
It kind of is. Mispronounced name. Good question. I'm currently searching for a family law lawyer. Do you have any suggestions on what to look for / look out for? Yes. Big firms, unless you know a lawyer there or have a direct referral from someone who has worked with that lawyer, just be cautious. That's one thing. 2, I know that a lot of firms are going to charge a consult fee. and that might like sway you away, but do your background. And when you find the lawyer you want, like you can do background research on it. Talk to people. People are the best referral ever. So I have people that come in and they were referred to me by somebody. And yes, my firm charges a consult fee. That's the firm.
The other thing is, if you're getting a referral from lawyers and so forth, ask if they get a referral fee.
Yeah.
Because, and you know, because you may be getting referred to a lawyer not because they're the best lawyer in town, but because they pay for it. And yeah,
you don't want that. So I will refer people to lawyers that I respect, lawyers that have been a pain in my ass before, but I respect. I will never send someone to someone that I don't care for, or who I think is just a bulldog for no reason other than to be a bulldog. So talk to your friends, people who have been in that situation, and then reach out to people who have dealt with those firms. You can learn a lot about a lawyer. Well, learn a lot about a firm by its culture. So take your time, meet with people. Don't be afraid to spend the consult fee, because I will tell you that spending that fee and learning and finding the right lawyer for you is worth the money, because if you get matched with the wrong lawyer, it's a challenge.
the other thing I recommend is if they're, do you guys have something like Canly where you can like a
Nope.
free case law lookup thing?
We do not.
Oh, that's tragic, because you might be able to do some.
And what I'll say is family law, you will not see them. They don't
Yeah.
exist in because we don't have a lot of appeals that get argued like that.
Yeah, well, we also get like trial court decisions.
Oh,
but
we don't.
I just, you know, in Canada, one of the things I recommend is like go online, look up the lawyer's name, and see, do they have a lot of rulings that say F this lawyer? Not like rulings where they lose, because everybody loses at some point, but rulings where they lose and the court has specific commentary as to the competence or skill of the lawyer.
Yeah, that's a problem.
I just read an appeal a couple days ago where like the Court of Appeal had some real specific comments about like, yeah, this lawyer totally screwed up and should have known better. And it's like, yeah, that's something I would take into account when I was hiring a lawyer. So yeah.
Google, I will say also this: Google reviews, grain of salt.
Yeah, Google reviews are meaningless because people will review you based on their results, and their results are often not so much based on skill as they are based on what you bring to the table. So what often happens is you'll get somebody who's like, yeah, so I was, you know, I didn't tell my lawyer any of this stuff. I destroyed a bunch of evidence. We got caught destroying the evidence in trial. And then my lawyer fired me, and they're the worst lawyer ever because after that I got, you know, this horrible result. And it's like, you effed your lawyer at every stage, and then you're upset that you got this terrible result.
And you know what your lawyer can't say publicly?
Your lawyer can't say this is all your fault.
Yeah. So
now,
that's why I hate the Google reviews. Now,
that varies by jurisdiction.
There's a caveat. I will say, look at the positive reviews, because people that leave positive reviews. So every negative review with the lawyer, I would almost throw out. But look at the positive, not just what the review is, but what they're saying. Yeah. Listen to what they say about the lawyer. They listened to me. I didn't agree with them. We fought. We argued. Listen to what they're saying and read those. Those will give you an actual good idea, because people that leave positive reviews are when they leave them the right way, they give you an explanation about the lawyer and their priorities. So
I also I took down reviews ages ago because
can't
I do
do that.
criminal defense, and I ended up with
you can't do it.
Well, I ended up, somebody posted a review that was a glowing review. It was an amazing review saying, Runkle helped me when I was charged with SA. And I was like, I love the review, but at the end of the day, this is actually trashing the client. Like, the client is tanking themselves because now this is publicly visible, attached to their name. And I was just like, shut down, like Google reviews, it doesn't let you remove a specific review. So I was just like, everything, shut down everything, because I don't. And the thing is that guy was innocent, like innocent, and then he's just posting it up there with his whole name, like his name is up there, and I'm like, dude. And
that's why I tell people, like, when they do leave a review, I am very careful. I tell them, like, hey, you know what? Be honest, but you can be vague. I don't want you giving any specifics about your case. Don't do that. Like,
yeah,
you want to leave a review? Please do. I appreciate it. And what's interesting is, I'll save that comment for another day. Blessed in Texas, Rob, I sent you a private message on IG last Friday. I also saw your follow-up to that saying, thanks, guys. Y'all are fun. You guys are fun. I'll email the message. I will take a look at my email. I promise. B. Hartling, Rob, for the pet buttons, check out Fluent Pet. Fluent Pet.
Can you customize those?
Oh, look at that. Yes, you can. They have kits. And hex. Okay, I'm going to deep dive that later.
Now, I'm just wondering, like, can you set those to be like, you record it with your
voice.
I don't want it to be my voice. I want it to be something else. I will have to, I guess, play. So it would just be like, okay, let's teach you the dog to swear at people.
Or not. Apple Silver, have you ever gotten a hole in one? No, I have not, but I have actually achieved 2 eagles in a single round. It was very weird.
Why are you hitting eagles?
No, just
aren't they protected?
Don't worry about it. You're not gonna. It's sports ball. Julia 543. Click and read about GFM for Moo. GoFundMe for Moo and share. Guys, I will. One of the things that I am careful about is any GoFundMe. I really, really, really am. And I know that there's a lot of very good needs out there. I also don't have the ability at all times
vetting is difficult.
It's difficult. And it's the precedent. It's the channel and the precedent. So the mods are sharing that link. The mods are, and I've encouraged them to share that link. Please check it out yourselves. Please do. And I encourage everyone that can to support everyone around you, all the charities, all you can do. I donate a ton to a lot of what you guys give. I donate back. I love doing it. Yeah. Lindsay, I also golfed ambidextrous. Totally a thing. I did not know that. Cat W, my husky has buttons and argues with me. He presses outside. I press later. He presses outside. I press later. And he huffs at me and presses now. Be careful. That's a husky. That's straight up husky.
Husky presses the button that says, I will kill you in your sleep. And you're like, I didn't even program a button for that.
Yeah. And guys, and to the chat, my mods know there's a rule that we're not going to discuss breaking news because I haven't had a chance to review it. I am aware that there was an incident in Loudoun County involving an exploding house. I will take a look at it, but I will not discuss it on stream because we are midstream talking about legal topics. I will review that later.
But this is also why you should maybe stay away from the Taco Bell.
injury reports. Bad joke before injury reports. Equality. I get some clients complaining how much tax they have to pay and how high their accounting fees are. How much they pay us doesn't affect their taxes. I know. Aurora W. I have recordable buttons for Leo. Will send. Oh my, I am now nervous. Okay, so swoop to last story. And Ian, I need your help with this one.
Uh-oh.
You sent the video from Hannah Gutierrez-Reed's hearing this week. That video will not allow me to play it. It says corrupted.
What the?
I don't want a lot, but I want to get the measure of the judge because this is a case where it's going to trial. And
Yeah, we can fix this.
So you can display it. I think you display it.
Include.
Okay, so now we've got the shiny head here.
Okay.
So we got the video. It's running.
This is Hannah's lawyer. And this past week, we had arguments over pretrial evidentiary matters. The trial begins this week, correct?
Yep.
Yeah. So we have pretrial evidentiary matters where they're trying to argue motions in limine, motions in lemonade, motions in limine, motions to limit. Basically, what we can and cannot introduce at trial. And both sides have their own motions. They say we want and we don't want, and please exclude or please include. The judge is like, I ain't having your bullshit.
Mm-hmm. And it's great.
It's fantastic. So play.
Provision that requires employees comply with OSHA standards and requirements. Yes, ultimately, they are looking at the employer. However, there is a provision that requires employees also comply with OSHA. Now, in their findings, Judge, which were comprehensive, they went through the various safety failures of various parties. Now, Mr. Genoway later says he finds that Ms. Gutierrez had issues in response to Ms. Morrissey's question, as did others. So these findings all are the context by which the jury should be allowed to review the prosecution's theories, which are solely Hannah Gutierrez-Reed caused the safety failures on this set, and they want to blame her, but then they don't want the jury to have the context that another state agency, a federal OSHA, had reviewed this, and they found safety failures across the board. Now, Judge, it would distort the truth, it would keep the truth from the jury, and it would present a lack of context of the whole set, because we have a set here where many people had things that they did that led to a tragic accident. It was not Ms. Gutierrez-Reed who solely caused something, and that's what the prosecution is trying to say. So they don't want us to be able to put in any defenses with regard to a state agency who found that there were multiple safety failures across the board by management. Now, that's highly relevant,
He's got a
and
very
it's very
shiny
important
head
to Ms. Gutierrez-Reed's case, because the prosecution's
Well, and sorry, bad pause.
going to try to blame her.
How long does that head take to
That's not
polish
bad.
each day?
No, it's not that. What the thing that drives me nuts is
Nostril cam?
and
He's got a
shaky
bit of
cam.
nostril cam.
It's your laptop. Why you are typing and maneuvering your mouse on the laptop and it shakes the cam every freaking time.
Yeah, there is no excuse
This
for having
camera is like stationary. I can do all kinds of stuff, and that's not shaking.
camera not moving. I'm tapping on my desk. It's making annoying noises, but it's not moving. Because this desk is
the camera. Affix the camera, sir. Now, I am not taking away from his argument, although I don't know. Where did you go? So context. This is an argument over whether the defense will be allowed to introduce the OSHA report. The OSHA report that said there were so many failures on this set. The failures were far reaching. They went everywhere. My God, this should never have happened because failures existed everywhere and the company is liable. Right? That was OSHA.
Yeah.
But OSHA wasn't focused on the culpability of one person.
Correct.
However, there is an argument to be made that this does provide context to that one person's culpability. But yet again, on the other side, that context can confuse a jury and say, because the whole thing was a clusterfuck, this person should be considered less culpable for their actions.
Which would be wrong.
That's a complex argument, right? And he's trying to make it. And I appreciate the tie. I like the tie, the knot. I love the good argument, solid argument. I would just like for the camera, sir, to catch your best features in the way that they are meant to be presented. And that is not this way. I want your best features to show.
I have actually been paid by a few different lawyers where I'm just like, hey, I'm going to need a budget and I will go and buy you a setup. And it won't be fantastic necessarily, but it will vastly improve your game. And there's things like camera should either be level with your eyes or above, never below, because below you get two things. One is nostril cam, and nostril cam is bad. Two is like chin camera. And women especially seem to hate being on chin camera.
It's not flattering.
No, it's the opposite of flattering. It makes anybody look awful. And you will. And the other thing is, audio, because what you'll see over and over and over again is people with like absolutely dog shit audio because they're doing it from their, from their laptop's mic, and your laptop's mic is going to be shit, right? It's going to be tinny. It's going to be whatever. And I literally watched somebody argue a bail hearing, and the judge was like, I'm going to adjourn this because I can't hear you. Yeah. And I can't hear what your arguments are. And so I'm going to put this over. And their client stayed in jail while that happened because the lawyer didn't have their shit sorted.
That's not disparaging, because the thing is, it's not hard. Just accept
it's a little
that
disparaging.
It is
sort your shit out.
Like accept that you can do something. Like, you might not be tech savvy, but now you kind of have to be. It comes with the job. You have to be a little bit.
And if you're not tech savvy, well, call me.
Yeah, we'll help.
Call somebody who knows what they're talking about, and but you don't want chin cam, you don't want nostril cam, because that's the other thing is people get their laptop, they pull it right up close, they push the screen down, and the camera is right up their freaking nose, and you're like, I can see your brain, sir, and it's not as big as you would like. So
that's mean. It might be fair, but it's mean. Okay, let's listen. The argument, though, the argument's good.
Solely for the whole thing. So it's important that we get to counter that with the appropriate context. Experts are entitled to rely on hearsay. Now, we're not asking to introduce the report. As this court knows, police reports are not introduced because they're hearsay within hearsay, unless there's some kind of exception that comes up. We're not asking to introduce the report itself, but certain of the findings certainly can be used by an expert under the expert rules in terms of their opinions. We're not going to ask to introduce that report, shady. However. But Judge, the premise Ms. Morrissey told you at the very start is wrong. Mr. Genoway said employees are also governed by some of the provisions of OSHA. Now, ultimately, their findings were against the employer, but they reviewed the entirety of safety conduct conduct on that set, and the jury's entitled to hear that. It would really, it would be a complete gutting in some ways of the defense if this court ruled out our ability to put in the context to the jury, which is what the prosecution wants. They don't want any defense, but that is a big part of our defense, in that other people caused issues, and multiple witnesses, Judge, of 49 interviewed in the.
Okay, so you made a comment of shady. I'm going to let's first give context. So this is a backhand. Well, it's a backdoor motion to dismiss one of their experts. So one of the defense's experts relied on this report in making their expert decision. Now, the caveat is the expert is a movie director, right?
Mm-hmm.
Yeah. So
And the expert doesn't know shit. So
doesn't know shit. So the expert is looking at OSHA and is going to give an expert opinion about movie sets, right? And say, this, based on the OSHA report, this is how a movie set would have done, and this, yada, yada. So there is a rule in expert testimony that says experts are allowed to rely on hearsay. They're allowed to rely on things that aren't really relevant. They're allowed to rely on damn near anything to make their expert conclusion and opinion. Their expertise gives them that ability to filter through the bullshit. And if it adds to or removes from their opinion, that's subject to cross. So Hannah Gutierrez wants to introduce an expert that is a director to testify that based on the OSHA report, having reviewed it, in that film director's expert opinion as their expert in film directing and set management, that this could never have happened but for all of the other failures. That is a problem logically, but I think the judge makes the right call. Logically, here's how the problem exists. I don't care how many failures exist in the chain of failures. If your failure was a direct and proximate cause of the death of one of those individuals and was an actual cause of the death of one of those, you are chargeable. And you can allow a jury to make their conclusion that you, independent of all of the other junk, are responsible. Just because someone might be more responsible doesn't mean you are not responsible. You can say less responsible, that's fine. That comes to sentencing. But not responsible is a different question. Right? Am I right in that reading?
Yep.
Yeah. So you are either responsible or you are not. Your level of responsibility is that's a sentencing debate. So what the judge does, well, I'll pull that up. That's why this is kind of a red herring. So Ian, you had an opinion on the report and whether it comes in at all.
I would have said, don't let it in. Like he's already saying the report is not admissible. It's like, cool. So why are you trying to sneak it in through the expert? Because what else does the expert know? Does the expert actually know anything? I don't think so. I don't think if you take this away, the expert's value is nothing.
Yeah, but let me push back on that. What the judge makes the ruling on is that might be fair ground for cross. Because this expert, if they put them on as the expert in film studies or film director, and you cross them on their knowledge of firearm safety and weapons and all the things the OSHA report evaluated.
Experts have to get to a certain threshold of usefulness.
That's a Dauber hearing. That's a Dauber hearing.
But I don't think that, we've got the Dauber hearing itself, but we also have the issue of, you've already said that this report is inadmissible. So why are you trying to sneak it in through this expert that has no other value? Like, they have no other things to say. I would have said, listen, if the report's inadmissible, then it's inadmissible. You've agreed that you can't tender the report. You can't tender the conclusions of it. So, and I might have said, okay, listen, tell you what, you can use the report only for its factual findings, but not for any conclusion about those factual findings as to fault, as to anything else. So the only thing that expert can testify to as of this is based on like what they found happened, i.e. you can testify that there was a negligent discharge elsewhere on the set, but you can't testify as to their conclusions about why that happened. So
I don't know. It's debate, but do you have the judge queued up?
No.
Wait, I thought you did. Hang on. It was right here.
Oh, I've got the video.
Multiple witnesses
But it's
talk
not
about
timing.
safety failure.
For the death of Helena Hutchins,
Hang on.
what he is saying,
So here's the back. Here's
Put
the other
that into
side.
context.
Your Honor, if I may do a brief reply.
Ty is right there. I wore
So,
it into a court hearing.
Mr.
so.
Bowles continues to say in his pleadings, and now during this hearing, that the state is singling Ms. Gutierrez out,
Oh
and
God,
that
she's
we
so
are
whiny.
holding her.
So, not to be on a negative comment train, but we made the comment about the other attorney. Get rid of the nose cam, guys. It is not fucking hard. It's not hard. Like just elevate your camera, put it up here, put it on a different platform. Like the webcams these days are like $40. They are nothing. They are $40. Like that's a quarter of a billable hour. Throw it up there, like boom.
Well,
right
the
there,
thing
boom.
is if they offered you a course that would make you like 10% more effective as a lawyer, people would sign up for that like nobody's freaking business, right? 10% is huge. And I think having good audio visual in an era of court appearances is that kind of product. Like, so drop like $1,500 on it. I don't care that you've got a laptop. Get a mic, like a decent mic, and it doesn't have to be like a big fat mic like this thing. Just a little like small mic is fine. But it's got to be decent quality. Get a what is it? Get a better thing. And somebody's saying I need a quiet keyboard. This is a quiet keyboard. The problem is that these mics pick up sounds really well. So
hang on. I'm gonna do this. This can be interesting. So I just checked the image twice to see if it's an okay thing to share. You've seen my space where I stream from, right?
Yeah.
And it's a dedicated space, but it's not like it's not crazy. The lights are a little crazy, but you know what? It's fair to say. So I am not a professional streamer. Do I have to caveat that? I think I kind of might be by this point, but I don't know. I don't care.
Rob is a professional streamer.
No, I'm not. I should know better, right?
Oh, I'm sure you're I'm sure you're doing better on the streaming behind the scenes than I am.
There.
I don't have any of that.
No, but that is a full ass streaming setup. Like that is lights that are on me. That is a computer that is up there where I can throw different tabs and things. And the camera is facing down at me with light at my face.
Yeah, I got to get better lighting. I got to get all of this other stuff. So,
and yes, one of my mods, Sandy, is in the background hanging out with us and making sure that y'all behave. But that's the setup. That setup, you downgrade the you can make that setup or a similar setup for $500.
You don't even
Easy.
need that setup. You just like a decent webcam, a decent mic, and you're way ahead of all of that.
Mm-hmm. Yeah, it's not hard. It's not. And I have a setup at my office. I have a setup downstairs in the shop. It's not expensive. It's not difficult. You
Responsible
can
for
do
this
this for
incident.
cheaper. Like, just be professional. So Morrissey is going to argue a lot. And I actually agree with her on some of this stuff.
That is a lie. Mr. Bowles knows that what he is saying is a lie. Mr. Halls was charged. Mr. Halls entered a plea. Hang on just a second. Mr. Halls was
That was inappropriate. I paused it here. That's inappropriate on her end.
Yeah, it is.
Calling him a liar? Fuck. Like, I would be stepping in too.
Oh yeah. These two do not. This trial is going to be fireworks.
Oh, it's that said, Bowles is a bit of a fuck up, so that is true. I'm not going to send you guys a picture of what my setup looks like because this whole space is a disaster. This whole space is a disaster.
Press play.
Don't you also?
Mr. Bowles, you may do us a reply, please. Let her finish.
Okay.
Mr. Halls was charged. Mr. Halls entered a plea. Mr. Baldwin has been indicted. The people who the state believes have criminal culpability for the death of Helena Hutchins have all been charged. So let's make that clear. Every time Mr. Bowles says that during a hearing or in a pleading, it is not true, and he knows that it is not true. Having said that, yes, of course, OSHA is going to look at the conduct of employees in order to determine whether or not the employer had adequate safety protocols in place. And that's exactly what they did in this case. And look, this is the case of Hannah Gutierrez. And there are certain people that Mr. Bowles, under the law, can point to and say, this person shares responsibility with her. Alec Baldwin is a perfect example. Mr. Bowles' defense is going to be Alec Baldwin pulled the trigger and he shouldn't have pulled the trigger, and that causes issues with proximate cause. Those are all legitimate legal defenses.
Yeah.
And OSHA
Why do you sound so whiny and angry
that basically
and loud?
finds Rust Productions had some liability, but doesn't comment on the fact that there is evidence that Hannah Gutierrez brought the live rounds on set. There is evidence that Hannah Gutierrez did not find. And
I'm sorry, Ms. Morrissey, and this is not disparaging. What Ian is saying, why do you sound so whiny? Because here's the thing, you could correct. This is a setup correction. This is a setup correction.
It's partially a setup correction. It's also partially that she needs to do a dry run of her talking with someone else, because she is shouting at her screen because she's getting zero feedback. She's not hearing herself.
She can't, and that's the setup. What I mean is that, like, for right now, you and I have been doing this long enough where I know that if I talk in this microphone at this level, you can hear me just fine. I can make my argument just fine. I don't have to elevate my voice or yell because I have to get closer to you to yell.
We also have chat who will be like, Runkle, your voice is way too hot. Tone it down. Or they'll say, like, I hate hearing Runkle's voice. And I'll be like, why do they hate hearing that? And I'll watch, but I also do recorded videos where I'll talk to the camera and then I'll listen to it because I'm editing it. And I'm like, oh shit, I sound like hot garbage. I got to fix that.
Is your mic right now, is your mic low or high? Is it low? Beneath you? Low.
Yeah.
Okay. So your mic is low, but the gain is picked up. So it can pick up just enough to get your voice, but not too much outside. Because I can hear when the dogs are barking, but barely.
Yeah, I mean,
Having that
ideally,
knowledge.
the problem is that certain sounds really pick up. The mic really picks up certain sounds. And so, like the dogs barking anywhere,
High pitch. It's going to
the
get
mic picks it up. The keyboard, like I tried with my wife. I was like, can you tell if I'm typing in here with your eyes closed? And she couldn't. The mic picks it up really, it picks up those clicky sounds. So
I got rid of that by having the boom that comes from the side of my, like the side of my desk, all the way over just to suspend it over my keyboard. Because I found that if the mic was anywhere on the desk, when I typed, it would hear the resonance on the desk.
okay. I'm thinking I need to get one of those little cages like that, like the shock cages. So I got to figure all that out, right? That's still stuff I'm working on, but she needs to hear her voice and she needs to realize that she's coming in with kind of an entitled sound.
She's screaming.
Yeah, and well, she sounds like she is feeling entitled to the win.
Well,
and
what's funny about that is that when you're in court, let me tell you this. This is what's unfortunate about Zoom. And Ian, you can agree or disagree. If she were in court at a podium and had the ability to project and stand and project,
yeah,
I think we would get a different presentation.
I think she'd be better at a
at a podium. She'd be a lot better, right?
Yeah.
Both of them would be.
And I think part of that is that she'd get the feedback from hearing her own voice.
Yeah.
And also the feedback from she's talking to a jury. She's going to see the jury's reactions to her expressions. And then she's going to moderate because you do that, right? You change your tone when, but yeah.
These comments, Ari, you're not alone. The comments that we get, it's okay. Just listen to your law stuff, have some fun, hang out. We're good. I love this judge though. So we have to get to the judge.
Live rounds for 12 days until Helena Hutchins was shot. None of that is in this OSHA report. So if we have experts take the witness stand and say, I'm a Hollywood director and I read an OSHA report and I'm here to tell you that Ms. Gutierrez didn't do anything wrong, we are so far afield of what expert testimony is supposed to be. Expert testimony is supposed to be reliable. What the expert relies on has to be relevant. If the court eliminates the OSHA findings from the trial, what the court will be doing is just simply leaving the jury with the relevant information and the relevant evidence. This is not relevant evidence. This is a smokescreen that Mr. Bowles wants to use to convince a jury that Hannah Gutierrez has absolutely no culpability when OSHA was simply not tasked with answering that question. Thank you.
Please tell me she's not arguing this case. Is she the one doing it?
Yep. Yep. I'm told she's really good on cross.
Yeah, because you can't give her a lot of time to talk. Because I now get it. Chat, I now understand. Chat, I understand. I now understand. It's the dramatic, like, teenager. Yeah. To be fair, I would do this if it was a guy. I don't care who the fuck you are, but that was terrible. And they do hate each other. They hate each other.
and they need to get over it.
They do. They need to be mature. And the judge tries.
Yeah, I'm not
Well, you tell me.
I don't like her delivery. I think that she turns a winning argument here into a loss.
Yeah.
And I don't think that's great. Now, I mean, I think she's going to get a second kick at this because when they actually, I mean, first they're going to have the Dauber hearing on with respect to that expert, and she may be able to kick him out.
Are they doing that like Monday?
Yeah. They're doing that before the jury comes in.
Yeah.
So she may be able to keep that expert out because she might be able to say, listen, there's nothing that expert actually offers.
I agree with her on the Daubert. I'm with her 100% on the Daubert. I don't think this expert has anything to give.
Yeah, no, I think this expert is a complete waste of time. Like, I think that this expert's purpose is to mislead the jury and shouldn't be allowed. But
yeah,
that's its own sort of problem, right? So it'll be interesting. It'll certainly be interesting to see how this shakes out.
But Judge, bring some sanity. Before that, boyfriend also asked why I ordered Uber Eats for one small McDonald's cheeseburger and small fries. Ari, you didn't order ice cream. You failed. You failed tonight's test.
You don't order ice cream via Uber Eats.
But you had to try, and they would get the message.
No,
it's not an order. It's out of order. It's out of order. You needed the out of order message.
And then you get melted ice cream because you shouldn't order.
It's 99 cents. Like, well, no, nowadays it's probably $2.
No, it's like $72 because it's nowadays.
Sorry. All right, Judge, bring sanity.
No, that's not how this is going to work.
Judge, thank you. Thank you, Your Honor. Judge, actually, that is not correct. The relevant information is the context of the OSHA report. Now, if Miss Morrissey's case was just individual, discrete instances, for example, loading the firearm, for example, how did the live rounds get on set, which we have plenty of evidence it was somebody else that put those live rounds on set. But if they were just discrete instances, then her argument would make more sense. But what they want to put on a trial, and the court will see, is a series of, they're going to show this whole set was negligent in their opinion. And they've written this in pleadings. There's negligence all over the set. Well, the problem is then the jury doesn't hear the context of the findings by the production and everybody else that caused these safety failures. So we have interviewed Lorenzo Montoya, the investigator, and Bob Genoway, the supervisor. Those people are we're not talking about, they're not experts. They're the actual people who did the investigation. Now, we're not going to ask a Hollywood director to say because of OSHA, there was nothing wrong. Miss Gutierrez.
Oh, that is exactly what they're going to do.
That's great.
That is exactly what they're going to do.
Mm-hmm. Pro tip: when a lawyer in an argument says, "We're not going to do this thing that you're worried about,"
that is what they're going to do.
Exactly what they're going to do. Oh, someone screen grab this. Mark my words. If this guy gets in as an expert or girl, oh, that's coming. I can't wait to be proven right, and Ian can't either. This is great.
Yep.
Reed did nothing. We're not going to do that, but that's a separate motion. That's an expert. She can attack the expert later. And the last thing, Judge, I'm going to say, the personal attacks, I do take objection to, and I'm going to put that on the record because it's been in the pleadings and it continues by Miss Morrissey.
Oh, that's going to continue even further because
it gets worse.
Thank you. The court makes the following ruling with respect to the state's motion in limine to
My God, thank you, Judge. You are my lifeline. You are my favorite person in the world right now because you know what she did?
She made a ruling. Nobody ever makes
Im-
rulings in these.
Immediately. And she announces it. And she goes, the court's gonna make the following ruling when it comes to this. It was so clear. Oh, thank you, Judge. You know what? I don't even care if you're right or wrong. I care that you made the damn ruling. You made the ruling. Oh, beautiful. And it was immediate. It wasn't like she was delaying. Like, I get your bickering, you're back and forth. I don't care about the personal bullshit. I'm going to make my ruling.
Prohibit use of testimony of OSHB findings and report. The court denies the state's motion in limine. First, the court finds and concludes that pursuant to 11401 NMRA, the OSHB findings and report constitute relevant evidence because it has a tendency to make a fact more or less probable than it would be without the evidence.
Which fact?
And the fact is of consequence in determining the action. For instance, the findings and report may impact the state's theory of causation. Second, pursuant to Rule 11-403, the court finds and concludes that the probative value of the OSHB findings and report is not substantially outweighed by a danger of unfair prejudice, confusing the issues or misleading the jury. Rather, the state can address any perceived limitations of the report via cross-examination of the witness by whom the report is addressed. Defense, prepare that motion.
Yes, Your Honor.
All right.
The judges.
We're going to move on to the motion to
Mary
sever
Marlowe Summer.
charges and exclude mention of alleged other bad acts.
Oh, this
Go ahead.
one.
Good
Good
afternoon, Judge. I'll be arguing that on behalf of Ms. Gutierrez-Reed. We are the movant. It's my understanding the state, notwithstanding us being the movant, actually carries the burden here to show a fact and consequence. I can go first, or the state can go first. Typically, the state would go first because they bear the burden.
Every lawyer looking down at their fucking laptop.
Yeah.
Can we stop?
This guy also, he needs to talk to Hannah about getting some of that white powder because he's nearly comatose.
That's tough.
He
He's
is
younger, Ian. He's scared. Let him be scared.
It's not that he's scared, it's that he's napping. He is barely animated. Like,
Ms. Morrissey.
This is not my motion. I don't see why I should have to
Do
go.
you wish to go first?
No.
All right, thank you.
Okay. Judge, we filed our initial motion to sever this tampering charge, and we challenged the state to come forth with some theory of admissibility. In their response, they spell out how they believe these acts are connected, and those arguments are based solely and completely on speculation. For instance, in the state's motion, in the state's response, they indicate that Hannah was nervous in the presence of police officers, and they attribute that to potential cocaine use. That's not supported by anything.
Wow.
And they identify a plausible alternative explanation as they're discussing it, saying that she could be under the excitement.
How long do I have to go? Where does he stop?
I don't know that he's ever actually started.
If he
Like-
goes slower, we're going backwards in time.
I feel like we're going backwards in time right now.
In
what I mean.
conformity with
Oh, he's still going. Hang on. That was 2 minute.
they
You
make
didn't
reference
actually
to,
notice that you'd
"I just
paused him?
smoked," and then the state puts in
Because-
parentheses referring to marijuana. The government, in its argument, marijuana use is not similar in nature to joint.
To introduce.
Oh my
Gave
God,
the
it's
state
killing
a
me.
deadline
Hang on.
of February 2nd.
Hang on.
To Ms. Reed.
Can we summarize his argument? Because I remember it. Like, I remember the argument, like literally the prior bad acts. They couldn't tie the marijuana use to that instance in that moment, blah, blah, blah. Is this the apartment one? No, that was later.
I mean, the summary is also that your brain at this point is going to want to
Fall asleep.
collapse inward on itself.
All right, let's hear Morrissey wake us back up with her animated response.
If the jury were to believe that she is someone who the government wants them to believe goes to work while she's intoxicated, that has extreme prejudice, and there's no probative value because they have no foundation for that. Furthermore, Judge, the state did not address in their response the argument
I'll
specifically
be right back.
about
Gotta let the
rule
dogs
on
in, but
jointure.
he's not going to get through more than 4
5203.
sentences before I'm gone.
Yep.
5203A1 states that you have to have acts that are similar in nature to join. The two crimes here that Ms. Gutierrez-Reed is charged with, tampering and involuntary manslaughter, they're very different from one another. They're not similar acts. And 5203A2 says to join, you must have acts that are linked together as a series of acts. Here we don't have that either because there's no evidence actually linking the alleged tampering with the alleged involuntary manslaughter.
Oh my God,
So
that's terrible.
we would ask, Judge, for those reasons for the defendant's motion to be granted and for that count to be severed, and also that the state be prohibited during the involuntary manslaughter trial from bringing any of that up.
I do want to
about
congratulate
substance
this
abuse,
guy on inventing time
anything
travel.
about drug use, and this specific act of alleged tampering. Thank you.
Because I was gone for a minute, and chat, I bet you thought I was gone for like 10.
Here's the thing. I wanted to pull this up. All these people seem somewhat incompetent and don't take Zoom hearings seriously. I'm not blaming the people.
I'm a
like
little.
a little bit. But to the people that said we could have court remotely, you could have arguments remotely,
We
could
can.
do all of this remotely.
Now, I'd show up for all of this in person, personally,
In fucking person.
because it's important.
Yes. There's a thing in sports ball that you hate, Ian, that players comment on when they get and they touch the field, when they actually are on the field for that game day. There's the experience. There's what they do. They put the suit on, they walk in the building, they do this, they touch the grass. There's a different energy that brings to your argument. You have a different feeling of consequence. That's why you're in person. You argue it.
Well, I also don't. I
this
think
is
it's really
speech.
hard to golf remotely.
It is.
Like,
This was a
I feel
speech.
like that's a challenge.
This was terrible. That was the worst argument delivery ever. It was a reading. It was a reading of a dissertation. Persuade. Your job is to be theater. Your job is to be charismatic. Your job is to persuade and orate and argue.
Mm-hmm.
There was none of that. But Morrissey, she gonna come in with some more.
Ms. Morrissey?
Your Honor, I'm a little confused just in terms of the procedure and the motions that we're hearing today.
Whenever a lawyer
The
says
court
they're a
gave
little
the state
confused,
a
what they mean
deadline
is
of
fuck you.
February 2nd to file a 404B notice. We did that. We filed it on February 2nd. The defense has never filed a motion to exclude the specific things that are in that 404B notice. So I'm not sure exactly where we are on actually addressing the 404B issues that the state wants to get into. What the defense is not allowed to do is to look at our 404B notice and then just kind of incorporate into their reply their motion to exclude, because by doing so, it doesn't provide us with the opportunity to file a response. So I would ask the court to give us some clarification in terms of how we need to address all of these 404B issues. Having said that, I can move into the motion to sever. So
Let me address your concern.
Sure.
So in your response, you identified not just the conversation about the cocaine after the death. You went through all these text messages that you intended to introduce.
Yeah, get
And
it.
you said that these all showed that she was working impaired. So it does go to the severance motion. It's basically in the severance motion, but you also noticed it in the prior prior bad acts. But we have to address it in the severance motion, because you're maintaining that her being under the influence offset, because all these texts are offset is a series of acts connected to the manslaughter. And so you also state in your response a couple of things. Number one, and I think this goes to Mr. Bullion's response, that the jury's going to be able to conclude all this.
Yeah.
This is not, you have no expert witness, to my knowledge, that's going to say, if you do alcohol, marijuana, and cocaine, and I don't know when this expert's going to be able to know, other than the marijuana the night before, and not knowing any of the amounts, that she worked impaired on October 21st. So you also say that you have many people, you have extensive texts, which I think we have the extent of them. And then you also say you have many eyewitnesses to her using drugs on the set of filming Rust. And the big question for the court, and what I would like you to address, is the nexus between your allegations of her drug use and her impairment on October 21. Because at this point, I agree with Mr. Bullion. It's completely speculative.
Okay, Judge, I'm going to give you some big kudos, because you're looking at the camera, not some screen on the side. Like, you are looking
Well,
at
it's
your
because
audience.
she's got people who set up her shit.
Oh, I know. But and there are the commanding judge stares that you get in court, where it's like, I pull my glasses off, and now the judge is like, you're going to listen. And when the judge pulls the glass off and they stare, it doesn't have the same impact if they stare at like the image of you on a screen over here. But no, this judge knows stare at the camera. And it is literally, you better create a connection. You said a lot of shit. I want receipts.
Correct.
I love this judge. I want this judge in all of the hearings.
No, you don't, because she'd
No,
do it
I-
to you too.
I know, but I would rather this, because you know what you're getting. I get a ruling. I can appeal it.
No, you can't appeal it, because she'll
So
get you a
until
ruling
you
that
can-
is, that's going to hold up.
Yeah, well, she'll make the right one, and it'll suck because I'll know I was wrong. But that's the point.
I'm hopeful that your statement is what is the nexus for you, because you're going to have to identify what the nexus is.
So, Your Honor, one of the primary issues in this case is that
Here comes the bullshit.
the negligent act is not limited to October 21st. There were a series of negligent
No, this is actually a better
acts
argument here.
that we have very concrete evidence of, that Ms. Gutierrez was engaging in these negligent acts as she moves through the filming of the movie during all of those days. So during the days that you're seeing the text messages between her and Mr. Trujillo about using cocaine, she's showing up to work the next day and
Oh, that's a bad pause. I am sorry, Attorney
No, you're not.
Morrissey.
she is
Nope, that's even worse.
failing.
That is somewhat better. This is why you want an animated attorney for Miss Gutierrez, because the point that she is making is utter bullshit.
No, it isn't.
It is.
Disagree.
Come on, man. She has not drawn a temporal connection. She has said in prior occasions, this was occurring, this was occurring, this was occurring. Get me to the day. You can't say that this vague period of time these things transpired without actually testifying to habit, not just random occurrences. Habit.
This isn't
Every
a habit issue. This is an issue of, what do you call it? This is that.
No, this is bullshit. This is bullshit.
It is not bullshit.
Come on, tell me how it's not bullshit.
Because this is not like the allegation isn't you were only that this was only an issue on this particular day.
False.
The issue
That is actually the allegation.
No, the allegation is she was careless writ large in the performance of Rust.
False.
And
false. That her careless actions led to this event. That in temporal time, the careless actions, the negligent disregard,
including ammunition ending up on the set on which was present on multiple days.
I understand the multiple days part.
The multiple days is relevant. It is critical, and it is the point here.
Get me over 403. How does the prejudice not overwhelm the relevance?
Because does it not go directly to the issue of like
I don't
what
think
happens
so,
with
because we're talking about that particular
What
day.
is the number one question that your chat and my chat ask me every time Rust gets discussed? Every time.
How
did a live cartridge end up on this set?
Yeah, it's always how.
So this is what answers the how did a live cartridge end up on this set.
Yeah, but her argument could be less shitty.
She's not making a great case for it, but this is the critical thing, is how does a live cartridge end up on this set?
I would have preferred your argument for hers, because hers sounds like a bumbling mess of bullshit and innuendo that is hoping to get the judge to latch on. Yours had coherence and logic.
The problem is she's not doing great at delivering her argument. But the argument she's making, I think, fundamentally is an argument that's got merit to it, because really what we're talking about here is how does this end up where it ends up? And I think that is a critical issue that the court is going to have to deal with.
Here's the other part that I think that you could have argued, that she should have argued, that in the days prior with that occasion, we don't know when that specific round ended up on set. It could have ended up on day 5, day before, day 6, day before. It could have ended up on any one of these days when she was in the residence under the influence of drugs. It was just happened to be there on that day, but it was connected to, I see it. I got it. I'm there.
Yeah. And I think that's sort of our critical thing here, is just like, there's a lot more to this one. So
I hate the way that maybe it's just the way that she's doing it, because it's the bad people bad, right? You get that impression, bad people bad. That's a connection. We don't have to prove any connection to it.
Yeah. And I think she needs to do a better job of actually arguing her case. But at the end of the day, I'm there on the, on the fundamentals of this. So, I mean, I think it's incredibly relevant. So, and this is just lawyer ball. This is how lawyers like go through shit, right? Because
Yeah.
And like
Ian and
we
I-
disagree
Ian and I,
about stuff.
Like we do this
But
on
that's-
the phone, like
Yeah.
privately.
Disagreeing about shit doesn't mean disliking people, and that's a fundamental that's a fundamental aspect of life, is that you should ideally be able to disagree with people and still come away going, I like this person, right? Or
Yeah.
you know, or at least I can respect the person, even if you don't like somebody. Like, you don't like, just people have lost all of that, and it's tragic because how do you learn things if you can't disagree with somebody?
Well, and when you swing for the personal, you lose sight on the argument that could be made. You made that argument more coherently than she did. When she was making it, I was 1000% opposed, but it took the logical, actual walking through it with me and debating it for me to be like, huh, she might have a point there.
And you know how many times I've been in court and like a judge is like, I'm not seeing this as an art, like I don't see this, and you have to explain to them, this is why this is correct. That is fundamental to lawyering, right? So if you can't do that, then it's not good lawyering. And
Now, I will say, I have a disagreement with the drug use in general, because that's not this argument. That's this argument. See, I have a problem with how they want to use it, but I will say the judge makes the point when we get to the ruling that says, you know, you can object when it comes. Like, we're not preventing you from objecting as the information is there. It's just, is this something that we cannot allow the jury, without any evidence being presented, to possibly hear? Like, motion in limine is you cannot go near this issue. I think the judge makes the right ruling. You can go near the issue, but wayward traveler who flies too close to the sun, be careful, because judge might bite or the jury might. You never know.
yeah, and that's the thing, is she is treading close to an impermissible argument. And that impermissible argument is propensity.
Yep.
You are the kind of person who would commit this offense. That is where, like, that's what the defense is arguing she's going to do. And I think she might. I think
will.
she's,
You know, she will. She can't resist it.
yeah, she actually did put it into her filings on that, and she shouldn't have. What she should say is, this goes directly to the handling of these specific cartridges and how these came to be on set. And
But
that's the argument to make.
You know what's funny is the entire beginning first, and I'm going to rewind it for 30 seconds. The entire first 30 seconds of her argument is so deeply entrenched in propensity that you can just feel from a guttural instinct that's what she wants to argue. And then she recenters.
Yeah. And I agree that I think she's going for...
Oh, she's going for it bad.
Yeah. And that's a problem.
That's where I have the issue.
Yeah. And I mean, I think the way to deal with that is not to...
not limine, but in the course of conduct.
Yeah, the instant she steps in there, you just say, that's it, you're done. And I'm not letting you make this argument anymore.
Yeah.
Like, you had your shot, you screwed it up, so you're done.
So back to the beginning, and I want you to listen. Like, how much is her tone? Understand where I had opposition.
Oh, yeah.
Listen to her tone and what she said.
So until you can, I'm hopeful that your statement what is the nexus for you, because you're going to have to identify what the nexus is.
So, Your Honor, one of the primary issues in this case is that the negligent act is not limited to October 21st.
This is the
There were
argument.
a series of negligent acts that we have very concrete evidence of, that Ms. Gutierrez was engaging in these negligent acts as she moves through the filming of the movie during all of those days. So during the days that you're seeing the text messages between her and Mr. Trujillo about using cocaine, she's showing up to work the next day and she is failing to remove those live rounds that are already on set that we can see in photos. And if you want me to show the photos where we can actually see them on the set, one of them we can see in her hand. One of them on the 13th of October is in her hand, for heaven's sake.
Let me just interrupt you, because it's not to me that it's in her hand. How are you connecting her use of these of marijuana? Coke was one time in these text messages. Do you have anything more than these text messages, I guess is what I'm asking, other than...
I apologize.
And that the intoxication of being blackout drunk.
Side note, I love when a judge has established that rapport, that when the judge goes silent, when you cut him off, you apologize, because the judge has already trained you as a lawyer. Do not cut me off.
I mean, this judge, I imagine, is a little scary to appear in front of.
Well, yeah, she immediately, all of my frustration with the argument, that judge immediately focuses in on and goes right to the point and asks a question she cannot avoid with the evidence that she has presented, meaning that she read it. She goes, you have one text message, two text message.
Yep. The judge is just like, I'm calling a little bit of bullshit on this.
Yeah. God, this is how if you are a criminal defendant, you want a judge that views your case like this fairly.
Yeah, I mean, I think she's not just good for like one side or the other. This is
she's fair.
I just want, like, on a, I get people who are like, what do we want for a judge? And I'm like, I want a fair judge. That's all I want.
Shot. Yeah.
Just let me make the argument. Let me, and so that's
clean
kind of
rulings. Clean rulings.
Yep. Something I can appeal if I have to or whatever else.
No bullshit. Don't let side stuff in.
Yep.
Clean record.
Yeah.
And she hits all those.
Yeah. No, I quite like her. I think she does a good job. And
that her admission to police officers that she drank alcohol and smoked marijuana on evenings, which I don't know if it's a paraphrase, and I'd have to see that. But I'm not persuaded that this use as evidence in the text messages is enough for you to connect her to the impairment. And the fact that you're saying that she was putting live rounds in begs the question.
So we have a witness who is going to say that Ms. Gutierrez kept ammunition in her hotel room and at the same time would become impaired by marijuana. So obviously the nexus there is we have a person who is in possession of ammunition to be used on this movie set, and she's high on marijuana. So that, Your Honor, I think absolutely.
She didn't make the comment. I just caught that. She made in possession of ammunition, but not to be used on the set. Well, maybe that's just me reading into it. Sorry.
It has to come in. There's no question about that. She's in possession of the ammunition and she's high on marijuana and she brings the ammunition to the set. So we have that. And look,
Let me interrupt you because these have to be specific. I'm going to make a ruling today. Being high on marijuana, that was on October 20th. Is that right?
no, Your Honor, that's not the one I'm talking about.
Which one is it?
But we have a
Well,
witness. Sorry.
Okay, so you have a witness that says off hours, she had ammo in her room. Number one, I don't know what that means. Was it on a shelf? Was she playing with it? I don't know what that means. So I don't know how probative that is rather than prejudicial. So if that's the series of acts that she was smoking high on marijuana, you have a witness to say high, and that she was she had ammo in her room, and you want to make the nexus that shows that this cocaine in her pocket or hotel that all these are a series of acts that show involuntary manslaughter. I'm having a hard time, to be honest.
No, and I apologize, Your Honor. I think you're misunderstanding me.
Oh, whose fault is
It's
that?
relevant that she's high
Whose
on
job it is
marijuana
to
and has the
communicate
ammunition in
that?
her room because we can demonstrate that she was impaired while in possession of ammunition that was brought onto this movie set. That's it. Full stop in terms of that.
When? Well, no, sorry. She made the connection of that was brought on to this. If you can connect, and that I think is my question. If you can connect the rounds that were on set to the rounds that were in her room, I don't have a problem. But if you can't, and you are instead saying that she has rounds of a similar caliber in her room that might be shot out of a different weapon at a different facility at a different time, and she was impaired when she had them, I have a fucking issue.
Well, the thing is she shouldn't have live rounds, period, while she's doing this.
I understand that, Ian.
They shouldn't be in her hotel room. They shouldn't be in her fucking imagination.
I understand that. But if she has the right to have a firearm, right? She does. She has the right to carry. She has the right to have a firearm, and ostensibly that right carries with it the right to have rounds in your room. You have the right to carry ammo. So she can have rounds in her room. Okay?
Sure, but there's plenty of things you can have a right to that
Ian,
are negligent.
Wait for a second. Let's say that the round that was the round that shot Helena
Hutchins.
Helene Hutchins. Let's say that was let's make it ridiculous. Let's say it was 9mm. And let's say that in her condo,
as opposed to a 45 long Colt, which is real less common.
Either way, 45 long Colt. I don't care. 45 long Colt, fine. But let's say the rounds that she had in her apartment or condo that were live were 9mm.
Right.
Can you not draw the disconnect between what she just said, Morrissey just said, that her intoxication around live rounds, the 9mm in her condo, is relevant to the discharge of this 40 long on this set?
Oh yeah, no, I mean there I would say that there's no relevance, but the defense would be standing up and jumping up and down.
But she hasn't said that. There's a big void in what she has said. That's
it's in their pleadings.
Well, I haven't read them yet, so that's my fault. That's my fault.
Yeah, it is like they do have that connection.
I just make the argument. I hate the way that she argues. I hate.
I
both of
agree.
them
She's
how they
not
argue. Like.
That testimony. That doesn't have anything to do with cocaine use. We have a witness, and look, tampering is always joined with its companion offense. For example, we frequently see a tampering charge because somebody disposes of a gun.
And this is a terrible analogy.
Does the state have to prove that it was a real gun and that it was the exact gun that was used in the killing? Of course not. The defendant disposed of the gun, and we have evidence to it, so it comes in. Ms. Gutierrez was under investigation on October 21st because somebody on the movie set died, and when she got back to her hotel room, she took what our witness is going to say she was able to identify as cocaine and handed it to her. And then she spent 4 weeks trying to get it back over text message. That's just tampering. Tampering doesn't get severed from its companion offense because it goes directly to consciousness of guilt.
There is a way for her to have made
Why
that
are you
argument better.
handing off a bag of your coke?
The way you and I hit pause at the same time, we counteract each other.
The way to do it would have been to say, not the gun, but that you disposed of a gun.
A gun.
And then, you don't have to connect it to the specific offense because that's the job of the jury. The jury draws that inference, but because it's open to the jury to draw the inference that the tampering was for the purpose of getting away with the crime, then it goes to the jury. And so that's why if you see somebody throw a gun into a river after a murder, it is for the jury can conclude maybe it's a different gun. Maybe he just was throwing it out for no reason. The jury can conclude those things, but they can also conclude, that it was for this purpose. And the jury in this case could say, we're not convinced it was cocaine. Although I think she makes the defense is like, how do you know what it is? And she's like, well, it's a white powder. It was identified as cocaine by a witness who has experience with cocaine.
And they texted about it.
And also Hannah asked it was a dime bag in a larger baggie. And Hannah texts asking for it back for the next month.
Yeah.
You don't do that for powdered sugar.
That's an argument you test in front of a judge to see how it goes in front of a jury before you ever put that in front of a jury. But I want to be clear to the chat. I have been rather clear from the outset that based on the allegations and information that we have gleaned, I believe that Hannah Gutierrez, and I will wait until I hear evidence of trial, but I am leaning very strong towards guilt. I don't need the drugs to get there. I don't need the drugs. I don't need anything. I don't need anything else to get there. I'm there. That, I think, is a clean interpretation of the law applied to the facts that gets me to guilt. A lot of this feels like bullshit. Like it's some of this feels like bullshit. I don't like a lot of the piling on. The drugs.
I would absolutely try to bring the drugs in
without a connection to that day. Give me the day. Show me that day that she was intoxicated. Give me evidence on that day that she was
Which day does the ammunition get there?
What a shitty case.
That's the thing, is maybe the jury finds that she brought the ammunition in on
maybe
Friday.
Prior, but the negligence
and maybe
existed prior to that. Yeah, what a shitty
maybe they
case.
find that she was sloppy with the ammunition
What a
because she was, because she was loaded.
That's the thing. I have her guilty. I have her guilty on without that. That's where I am. I'm guilty without that.
Sure,
with
but I
that-
mean, with that, you might get even more like, you know,
What I'm trying to balance is the weight of guilt evidence and sentencing evidence. And I put the drug use and the propensity stuff in the sentencing side. Right. So I have this clear division between what I use to determine whether someone did or did not do the thing and what I do to punish them for the thing they were charged or convicted of doing. The
I think
drug
it's
use,
also relevant to whether or not, like, to what the jury thinks happened, because the jury may have a question of how did these drugs get there, and the answer to that question might be because she got high. You know, Afro Man might have the answer to this one,
well, he's busy suing cops.
and I wish him the best on that. But I mean,
actually do too. Good luck.
but yeah, I'm not being sarcastic about that. Like, I genuinely do wish him the best on that.
No,
but
when I say good luck, I mean, like, honestly, like, you deserve to get your money back from the cops. I am with you on that lawsuit. Like,
but I mean, I think it's open for them to I think it's open for the jury to be like, yeah.
Okay. I'm with you. You can present it. Like, and the judge makes the call. The judge says you can present it.
Yep.
Cocaine to someone who you hardly
But-
know after you've gotten back from the police station. It's
Okay.
I think that's
can't.
perfectly reasonable.
Is very different.
Nope.
Some
Nope.
Oh,
Give me the judge. There we go. Give me the judge. I
no, don't interrupt him.
respectfully, folks, like,
tried to do that by
I understand people are going to be mad that I cut off the attorneys. I didn't hear the argument. I've heard it. I can't do the monotone and the screeching.
The voices of everybody are awful.
It is. You have one that's yelling. You have one that is sleepy. It's like cocaine and
Heroin.
yeah, it's cocaine.
She's angry,
and
he's nodding.
heroin. Yeah, it's a mix. It's and the judge is like, I don't know what to do, but my God, I can't do it.
making this in
You know what's funny? We summarized the arguments better than they could have. That's actually probably better. So,
I mean, it's easier for my
Impairment
chair too.
argument.
So
yeah.
which they cannot make. They don't have the necessary facts. They don't have the necessary foundation. They don't have the necessary experts. It's all based on speculation and a propensity argument. Absent some competent and admissible evidence that Miss Gutierrez-Reed was in fact impaired by cocaine on the date of incident, there is no relevance whatsoever to her possessing cocaine or any other drug.
Oh, you dissuaded me of that.
There's simply, it's
I think that
markedly
was a good
different
argument.
than someone concealing a murder weapon. They haven't established the relevance.
I think the other thing he
of
needs
this
to argue here,
supposed
which he doesn't,
cocaine.
I'm gonna pause. The other
Tried.
That was
the other thing,
simultaneous at the same fucking time. Sorry.
the other thing I think he needs to argue is there is another explanation for her getting rid of the cocaine, which is she doesn't want to go to jail for having cocaine. And regardless of whether or not she was using cocaine at the time, just not wanting to be caught with cocaine is a powerful motivation. And
Yeah.
so, you know, I'd be hammering on that, saying there's a perfectly good explanation that isn't evidence tampering, because this isn't, they haven't shown that this is evidence, is the argument he needs to be making.
Or relevant. It's not something they rely on. They don't need it. It's not there. She's just has cocaine.
Yeah, they need to say, like, this is not a connection that you can show, like, and this is me, if I was in his shoes, I'd be saying, like, you can't show that this is evidence. You can just show that it's contraband.
Yeah.
And so that's why it should be severed. And then the judge or then the jury can separately decide if this was evidence, but otherwise bring it in if it's not evidence. And they don't have they don't have a good case for why it is. All that gets us to is a mistrial.
Yeah.
If you want to threaten a judge on a high profile trial like this,
Mistrial.
you do it with the word mistrial, not the word that the other guy uses later, which is writ. Writ is the wrong word.
No, writ is a direct threat. Mistrial is I have to do this shit again.
Writ doesn't get him anywhere. He tries with writ, and the court just tells him to go F himself.
Yeah, well, a writ is good fucking luck because the standard is pretty fucking high. However,
yeah, but also the court tells him to eat.
Having gotten a writ favorably, it's a pretty good like smacking the face to a judge. Like I will say.
Yeah, this judge she gives zero fucks.
Oh no, this judge doesn't care. No, I'm not threatening that. Not with this judge. No.
Like this judge just is like, nah.
Yeah. So here's the continuation.
And they've failed. It
Your Honor,
has
I'm
nothing.
Wait, no, don't interrupt him, please. Okay. All right. The court
It
makes
has no-
She's
Do you
like,
see how that do you see how that works? Like
she's like,
judges-
listen, this is gonna take forever if he's allowed, like even if he's allowed to finish a sentence.
well, it's not even that. It's the judge immediately. Don't interrupt him, please. Don't do it. Just don't do it. We talked about the Fani Willis case
Mm.
and other cases we've covered. I need these types of judges. Judge Summer, please, can you teach judicial conference like abroad? Can you do this elsewhere? I need this demeanor everywhere. But yeah, don't interrupt. As I interrupted Ian.
It's okay. I wasn't making like court submissions.
on ruling. Or you're not finished, Mr. Bouillon?
No,
sorry.
Judge, I'm
Seemed very
good.
repetitive. Okay.
I'm okay. Thank you,
All right.
Judge.
All right. So I think I'm satisfied with what Ms. Morrissey was saying. The concern for me, Ms. Morrissey, was what Mr. Bouillon is describing as propensity, is these time periods of that you had quoted in there. So I'm going to make the following ruling, and then I'm going to identify a couple of things. So
Side note, I'm going to make the following ruling, and then I'm going to identify my concerns. Thank you. Thank you. Thank you.
Here's the ruling. Here's why I'm making it.
Just do the job. It's the job. It's the job. It's hard. It's really fucking hard. I get it. It's really fucking hard.
Somebody's gonna quote that phrase out of context.
I don't care.
Yes, you do.
I don't. Not when it comes to something like this. Just make the ruling. Make
Yes,
the
you do.
ruling. Let me appeal it. Make the ruling. Be clear in your ruling. Explain it, and then do it concisely. Don't allow a lot of bullshit back and forth. You heard argument from one side, the other, and then back. You don't have rebuttal. You don't have all the other arguments. You don't have 5 lawyers chiming in. You have one lawyer speaks, the other one speaks, the other one gets a rebuttal, and the judge is like, I'm going to make a ruling. Here's what it is, and here's why. This is how it's supposed to work. This is how it's supposed to work, people.
Katie Lee, I'm not
Rule
sure if I'm going to be able to
5203A,
watch it
it does
live.
talk about,
I may have
this
to
is
do
what I
recap.
was looking at, are based on the same conduct or on a series of acts connected together. So basically, what Ms. Morrissey's talking about with tampering of evidence is the same conduct or series of acts that she's talking about with the involuntary manslaughter charge. And so these series of acts are related to these charges. The state has a sufficient proffer that the following with respect to what she's planning on bringing in surpasses the argument for severance. So I do think that the text messages that you showed from 9/22, 10/16, 10/17, 10/18, 10/20, and 10/21, the relevant ones are the one where she's smoking weed with the ammo in the hotel room and that she's smoking in the jacuzzi. I think those are the relevant ones of the other of the acts that you in your response said you were going to show, plus the text messages with respect to after the fact with, I can't remember that lady's name, where she handed off the cocaine. But other than that, I do agree that the remainder of your intended text messages, as well as that intoxication the weekend before, are not that they're propensity evidence versus probative evidence, and they would be unfair to the defendant.
Understood.
And that's also how you get a ruling too. I'll give the prosecutor some props for that, which is that was a ruling that was a mixed ruling.
Yeah, push it.
And she's like, I understand, I'm moving on, right?
Yeah.
That I think is exactly what I want to see out of a,
Well, and she made it very clear. Like, I see where you're going with this, and I want to be clear. Like, all the other bullshit, that's propensity. You don't get that.
Yeah.
And I hope she sticks to her guns at trial. Like, honestly. But I love the judge. This trial is going forward next week. It's going to be streamed. It's going to be, these lawyers are, they are personalities. I love trial lawyers for this reason, man. They're fun.
I want to stream this. I gotta see if I can move my schedule around to be able to stream this live.
Oh, I can't. I'll be catching replays. I'll be catching all this stuff being replayed, and I'll be loving it because I love the theater. And there was a lawyer today in the Fani Willis case who was today he was a Georgia gentleman. He was a soft-spoken Southerner, and my God, you could tell how he controlled the courtroom. There is a demeanor of the epic and amazing trial lawyers that you cannot help but stare at. Like you watch them litigate. Clarence Darrow, right? We've talked about him in the past. You can't look away.
I seem to get the sense that you are a fan of Clarence Darrow.
You know this for the fact.
Yeah.
And you are too. Don't lie to me. You know you
I know.
are. He is the defense attorney's defense attorney. He's the guy that shows up in a suit that looks like it's been, run through the wash 25,000 times, tattered, and comes up and beats you at your best. And you're like, where the fuck did that come from?
Oh, I had a day when I showed up. I was traveling and I realized I'd forgotten my tie when I got there. And my suit pants and my suit jacket didn't match. And the judge was just like, really? And so I ended up arguing, like, I sort of had to apologize to the court. And so I ran this trial and I did well on the cross-examination of this one cop. It was a one cop thing. And he basically said that he saw my client do it. And I was like, did you though? And the cop was like, well, I think I did. I got him down to, I think I saw him. And I said, okay, so you think, but you didn't say you were pretty sure. You just think you saw him. And he says, yeah. And I said, okay. And the judge was like, well, I got to acquit. Based on, I think I saw him. Crown, do you disagree? Like, this was before we made closing arguments. And the Crown's like, no, I agree.
Yeah.
And he said,
I agree.
Mr. Runkle, you should know Clarence Darrow was in the habit of appearing like disheveled in court, but doing a good job. He's like, maybe lean into his other like maybe you don't need to lean into that quite so hard. And I was like, I understand.
The persuasive arguments part. Anyways, we're gonna land the plane. I have questions. Attorneys might seem expensive, but consider what will be lost long term. Yes.
Yep.
Yes. Thanks for helping my sis take a second look with your very busy schedule, Rob. I have questions I won't reveal. I don't know, but I'm glad that I was able to help. Joshua, thanks again for another great FNF and have a wonderful weekend, everyone. Indeed. K-Rab, I bought Fluent Pet just before the super hat. Looks good because you start with a small set. Well, that's confusing, but I will
Super
learn.
chat.
Oh, super chat. Yes. Sorry. Is the trial going to be streamed? I believe so. Yes.
I've heard
court
mixed
feed
things.
live.
And if they don't stream it, then there's going to be a lot of upset people. So
Yeah. J. Michael RN. No, we order ice cream via DoorDash, etc. a lot.
it
Yeah,
works
that-
better when you order like a big thing of ice cream. When you order on ice cream, I've had bad luck. But if you order like a liter of ice cream, it's got more thermal mass and holds up better.
Yeah, true. Lady Drake, who's one of my mods, fantastic, lovely, and so is Joshua. Wonderful people, love them. Kind of funny watching Daddy and Uncle Runkle fighting. Sorry, Rob, love you, buddy. Yeah, no, we argue and we have fun, and we are really fast friends. And what's funny is we do it in person, we do it on the phone, we do it on live stream. And what's funny about it is we might agree on a topic, but when one of us goes hard in the paint, like goes really digs their heels in, the other one can't resist but to try and blow it up. We might agree 100%, but watching the other one go in and just dig their heels in, that's not gonna fly. Nope, we're gonna fight. Angie, why was no one drug tested after the shooting? You started that, Ian.
Because cops don't always do the best job.
Yeah, they could have easily, but they didn't.
I mean, everybody has this notion of police is doing like a perfect investigation every time. I can tell you,
it's tough.
I mean, yeah, there's all sorts of things where that goes wrong.
This appeared like an accident. At first glance, you would not have wanted to like run up and be like, I want to drug test everybody.
Yeah, and I mean, this one was just such a tragic shit show. I strongly suspect that what they came away with was not like, oh yeah, we immediately think that they're like, yeah, and I've seen police do some really dumb things. There was a stabbing that I was counsel on, and the police determined that they had left the scene and nobody had actually put the knife into a police car. And when they went back for it, it was gone. So, you might say, why the hell would they not save the knife? The answer is screw up. So, all sorts of things happen. By the way, if you are a police officer, make sure you don't lose the knife.
Don't lose that. The other answer to that question is you might not have probable cause to do any drug testing whatsoever. There is nothing on scene that gives you reasonable suspicion that there was drugs in play. So you can't just test people.
Although you can ask, and
if they would volunteer.
A lot of the time people will say yes because they're like,
yeah, they will.
you know, well, I have nothing to hide. And it's like, ooh, that's a bold assertion.
Really, really bold assertion. EMZ, you're both the bee's knees, listening and learning. Thank you very much. Ari says, what's a writ? A writ is a writ of mandamus. You apply for a writ of mandamus to the
And
highest
there's other
court.
kinds of writs as well. Just
There are, but it's a writ that is a directive. What a writ is you are applying to a higher authority and saying, give a commandment. Please give a commandment downward that says this institution or body or individual must do this thing.
yeah.
So you're applying for a writ.
And like in this case, the writ of mandamus is that it specifically says court, or it specifically says to the like, you need to step up and do this job that you didn't do. So the job in this case would be, you failed to grant this, this motion in limine. You ought to have. So then the higher court can say, we're directing you to do that.
Yeah. Writ of mandamus, literally, you are mandated. You are commanded.
Yeah.
Yeah.
No, it's not a writ of Matt Damon. Matt Damon has nothing to do with these.
Cheryl Mills, thanks for being a member. Nicole has ADHD. Thank you. Thanks for company. Kidney stones, 0 out of 10. Do not recommend. Oh my
Ooh.
God. That pain level is unlike anything. I never want to experience that in my life. I'm sorry. I hope you fast recover. Time out. Thank you for helping me stay sane during these nights of new sleep. A new baby can be very demanding, but very rewarding. Congratulations on the new baby.
They
And
get
all of
pretty
the
awesome
blessings-
around like 20.
Well, all the blessings and wonderful wonders that come with it. Because I will tell you, like, no, I'm not going to. You'll experience that for yourself. Enjoy. Please enjoy. CS Tears. Law and Lover question. Did you see Uncivil's question about whether or not attorney-client privilege is criminal charge? Is that adultery is relevant to political case? Oh, the adultery issue in the Georgia case. Oh, they were going after the fraud crime exception. They were trying to say that the attorney, knowing of the adulterous act, was helping perpetuate a fraud by allowing and furthering a filing that said that it never occurred. And the judge shot back, which I thought was rather witty. The judge said, hadn't the Supreme Court said that you can't prosecute it anymore, adultery? And the lawyer says it's still in the books, which, mind you, in Virginia, we still use that. It's still in the books. So you can still claim the fifth to allegations of adultery. Interesting. I have to give that more thought.
I'm going to give it less thought.
You're not invading attorney-client privilege based on that assertion.
Yeah, I think that's crap.
Any judge in their right mind is not going to allow you to invade attorney-client privilege based on that. That's my thought. Like,
I would agree that is the correct.
Yeah.
Yeah.
You might have some technical argument, but I think the great weight of the argument, like holistically, legally, is against the privilege being waived on that issue. Angie, the question was in reference to OSHA and an employer. I'm sorry. The OSHA thing, that I don't like the report coming in because I think it muddies the water. but we'll see how they use it. I don't know. Billy's Momzilla, I'm confused. Drug evidence coming in. Oh, it's coming in. They're getting it in one way or another. It's coming in. Right now, the judge has said you can introduce it for limited purposes, but I guarantee you that DA is going to try and use all the purposes. So, without further ado, it has been a wonderful Friday. We are at 4:49, and I have to land this before 5 hours because I am a pumpkin. And
I was
Ian
going to say,
has-
I am starting to turn into a pumpkin myself.
Yeah, I am a pumpkin. So, without further ado, please check out Ian, Runkle of the Bailey. He had some great streams this week. He covered Hannah Gutierrez-Reed. He had a Monday stream, and he covered Friday last week. And on Monday, he will stream again. Please check out the channel if you have not done so. If you haven't, shame.
I got a whole bunch of stuff to cover, so
he's got a lot. He's got a lot. And then Gutierrez-Reed, I imagine, if there is an expert in this, it is Ian Runkle. So
I am gonna try to move my schedule around to let me just cover this, but I really want to just do live coverage of the Russ trial, and I'm gonna try to move Heaven and Earth for when Baldwin is on the block.
So this is one of the only trials that are live streamed where I will tell you that among my friends, I have a favorite. And it's not a favorite for a personal reason. It's a favorite for a legal reason. If this trial is live streamed and you have an opportunity to watch that live stream commentary on the trial on Ian Runkle of the Bailey, who is a firearms expert, trainer, educator, and lawyer, or anyone else covering the trial. Did I already suggest where you should watch it? Watch it on Ian's channel.
Yeah, I'm hoping I can make that happen. If I can't do it live, I will absolutely do it as what do you call it? Recaps.
Yeah.
So
that's a must.
So, I mean, that's going to be a lot of work because it'll mean doing court and then doing court stuff, listening to it in my ear and watching it on like double speed and then doing a recap. But I'll make it happen because it's got to happen. So I see Ian and EDB stream it together. EDB is usually a lone wolf. She usually does her own thing. If she wants me on, and if I'm not streaming it myself, I would be happy to, but she's a lone wolf, and that's not like I'm not kicking my way into her door. Like that's not how I roll.
We invite each other. We don't compel each other. We invite each other. So all right. To all you folks, have a wonderful weekend. Please be safe. Please enjoy your lives. Go out, make something. You will feel better. I promise you. Ian, get into the leatherworking shop. I will get in the wood shop, and we'll be back next week. Thank you guys for being here. Much appreciated. Happy Friday.